Y'all, all right, we should be back in the building. We should be all good to go. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're looking all crispy and clean on the screen. And I got to give you guys a welcome. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE, of patreon.com/ClassEbeats. By the way, make sure you check the link in the description as well as in the pinned comment in the chat. And today we've got a great show for you. We are going to pick up where we left off yesterday with Dr. Judson Welcher. He's on the stand. He is the accident reconstructionist. Is that a word? I don't know. Accident reconstructionist. He's going to show us what he thinks happened to John O'Keefe the night that he was tragically passed away. So we'll get into that, and then we'll get into court proceedings today. It actually looks like court hasn't started yet, surprisingly, well, or unsurprisingly. So it's good that we were a little bit behind. It's like I knew. No, I can tell the future up here. Either way, we're going to go ahead and get into it shortly. But before I do, I've got to say what's up to the people in the building, man. This show would not be possible without y'all. So let me say what's up to everybody that's in here. Shout out to my awesome, amazing Amy's in the building. First thing, reminding y'all to like the video. We've got 8 Baboon is up in here, became a new member. Slim Life is in the building. 8 Fits, Lady E, J Buckmaster's back at it. Unique is in here. B Dubs, good morning. Libby 22 SC girl, excuse me. Kara Hampton's in here. The Honorable Attorney Kel Bell is in the building. Said, what is going on? Good morning, everyone. Caught up on everything last night. WTL plus that from Dr. Welcher. Are we being punked? It's embarrassing. Embarrassing, Kel Bell. We're going to get into it here shortly. Kara Hampton's in here. Taco Tuesday. Had an amazing Taco Tuesday yesterday. Good to see you in here as well. Trisha's in the building. We've got... Oh, man. I'm going to say it right this time. Paua. I think it's Paua. We've got Paua Eyes is in the building. I think I got it right that time. Taryn Stewart is in here. Tatum. We've got Lady E. I think I said what's up already. CPE is in the building. Let's go ahead and get into it. I'll be saying what's up to a couple of y'all as we go throughout the show. But before we get started, I have to remind y'all to like the video and beg you, please like the video. All right. Not only is it free, not only does it help the show continue to grow, but it takes less than 1 second to do. It really does help us out a lot. It lets the algorithm know that you guys are enjoying the show, and it shares the video and the channel and this particular live stream out with more people. You guys are the reason that we're here. You guys are the reason that we're at 114,000 subscribers. So thank y'all for the support. And if you're feeling extra generous, you can share out the video on X, on Twitter, and text message, and let people know that we're here. All right. I'll also be reading super chats throughout the show. So let's go ahead and get into a couple of y'all that have already shown some major love. Let me see. I had someone last night I want to acknowledge just sent something random over on the Cash App. So big shout out, or I'm sorry, PayPal. Boy. Let me see if I can find this. Hold on a second. Over on the PayPal, we had, there it is. Shout out to In Blue over on the PayPal. Dropping the 10 bomb, says, thank you for recording. Have been working out of town and it's nice to listen after the fact. Not that it matters, but my YouTube account is In Blue. Shout out to In Blue using PayPal, hopefully, so less fees are assessed. All right. Appreciate that. And thank you, In Blue, for sending the love. I appreciate it. Also, as I mentioned, 8 Baboon is over there, became a new member. Welcome to the member side, 8 Baboon. Make sure, if you haven't yet, check out the members only content, as well as use some of the custom emojis that we have in the chat. I need to update those. I said I was going to update them this week, so I'm going to make sure I get into it and do that. We got Slim Life in here, a regular on the morning show, always showing love and support with the 5 bomb. Says, good morning, ClassE, Amy, and my amazing CEB family. Have a blessed day. It's hump day. You know what time that, you know what that means. You know what that means. That's right. Let's get it. Shout out to Slim Life, New Jersey in the building. We've also got Kara Hampton in here reminding us that it's hump day with the 5 bomb. It's a great day to have a great day on purpose. I love that saying. Let's go, Alessi. Much love, ClassE and Amy. And thank you. Much love to you, Kara. You show up every single show, every single day, and show some major support in the chat. So I appreciate you and thank you for the love and support. And y'all have a great day on purpose. It's up to you. You really can control it. CPE is in here, just gifted 5 memberships. Oh my goodness. If you got a membership from CPE, Make sure you say thank you. So generous, giving y'all a chance to check out the members only content, use some of the emojis, and have that beautiful green highlight on your name. So thank you to CPE. Always good to see you in here. Haven't checked out War Games yet. I keep saying I'm going to do it. I don't know. I'm just going to have to put it on my work calendar or something. I'm going to set aside a time. How long is War Games? How long is that movie? I'm going to set aside a time to just sit down and watch that movie. The movie is, it doesn't say. It doesn't say. An hour and 54 minutes. Oh my God. Okay. It's going to happen. I'm going to set aside 2 hours and I'm going to sit down and we're going to watch it. All right. Danny in real life is in the building. Shout out to Amy. Oh my gosh. Yeah. Amy says she's an expert now. Y'all say prayers. Y'all send prayers out for Amy. She's had, some rough goings yesterday and still isn't feeling great. So if y'all could say a prayer for Amy and for a speedy recovery out there as well. All right. So we're going to go ahead and get into it. So we're going to do a little bit of a rewind, go back in the future to yesterday. All right. It was the day 21 of the Karen Reed trial. We had Dr. Judson Welcher is on the stand. He recreates accidents, and he went through all of these steps to show us what could possibly have happened to John O'Keefe. He put the blue paint on his arm. He showed the car backing up and how it could have, if John was holding his arm at the right angle, it could have not only broken the tail light, but it could have be what caused him to fall to the ground and eventually hit his head. Now, it's interesting that Dr. Welcher did imply that head injuries could be caused from that type of accident. And obviously, most likely they would be. But we're going to get into the rest of his testimony, see what he has to say. And then I believe we have some other court proceedings that take place with the lessee and the Commonwealth. So let's go ahead and get into it. If y'all haven't yet, make sure you like the video on your way in. I thought I had it at a good starting point, but apparently I did not.
Mr. Lessee, Mr. Brennan is going to do this in open court. Just talk to Dr. Welcher for a minute. Okay. Yeah. Is there any objection?
I have no objection. Are we on the transcript or not?
Yes. Right.
Yes.
Okay, I made a minute.
Yes, I will be giving y'all some YSL updates shortly. Probably tomorrow.
Yes. Absolutely.
No talking, court still in session.
And we're going to remove the heading on each one of the slides. I don't want to repeat what it says, but on each one of them we're going to put the approx. Thank you. And now, that's all I've said. And I'm going to now use the 10 minutes to see if there's anything else and report to you.
So it starts on page 124.
Stats.
Is that right, Mr. Brennan and Mr. Lessee?
I don't have the whole one in front of me. Have it in front of me.
Dr. Welcher, is that where it starts?
That appears to be, Your Honor, yes. 124.
Good morning, Perfect Peace. Good morning, Nana Banana. Good to see all of y'all in here. And actually, I can speed this up a little bit too.
Start out 123. I have to start.
That's probably going to be too much. There we go.
I have it at 123 as well.
All right, I don't have it on 123.
Which one,
123 is
Kara?
a blank slide.
May I approach, Your Honor?
Yes.
I have 123 is a blank slide.
Okay. So
So from
124.
triple M.
Which trial you're talking about? Oh, the YSL. Yeah. Yeah, I'm going to be covering YSL.
124 through 138, is that accurate, counsel? Chrissy, do you need a break? Do you need 5 minutes?
Yes, Your Honor.
Okay. So if you could do that for us,
Absolutely, Your Honor.
Dr. Welcher.
I'm doing it right now.
We can bring the jurors back.
You can see they've got the camera pulled back because the juror's on
Sure.
it.
Sure.
And just share this over on X.
Yeah, confer with Mr. Brennan at one point. Mr. Brennan, can I ask you to approach you? Thank you.
Not on the record, Chris.
All right, we just got a bunch of busy work here. I'm trying to figure some stuff out with the PowerPoint.
Offend the court.
Here we go.
Subject to going back once the heading's gone, right?
Correct. There may be, depending upon what's in the video, there may be more. That's why we're
Right,
saying,
but the ones, all right, so we
So I can go back and show them.
Yes.
I don't want to offend the court.
Okay. So are we starting on slide 132?
132, Your Honor.
Okay, thank you.
May I inquire if Dr. Welcher's PowerPoint is ready on the screen?
It looks like it's up. Is it ready, Dr. Welcher?
You got me scared when you asked me that. I need to double check.
Come on, Dr. Welcher, get it together, man. Dang. I'm just going to skip forward to when the jury comes back in. Here we go.
Did skip over one.
There we go.
Dr. Welcher, if you could return to slide 132. Actually, 133, Dr. Welcher.
Is that me or? $132 or $133?
133, please. The next one after that.
So we did skip over 132.
We skipped over that one as well. Keep going. There we go. If you can enlarge that just a little bit for us.
Sure.
Now, you mentioned that there were studies that talk about guiding the difference between potential injuries.
Correct.
Okay, explain that.
Sure. So I gave 3 papers and someone's dissertation on this issue. They are creating a analysis methodology to differentiate whether the nature and pattern of injuries are more consistent with a fall or more consistent with an assault, or they're calling it blows.
Okay, could you walk us through what this chart means?
Sure. So this is their flow chart in terms of their assessment. So it starts at the very top. You can see they analyze a total of 400 events, 235 falls, 165 blows or assaults. So what you do is you ask yourself on the first set of arrows, you look at the mandible, the jaw. And MRS, as you can see at the bottom down here, refers to a simple fracture or multiple fractures. A is no fracture. Mr. O'Keefe has no mandible fracture. So that means we go down this row. It then looks at all.
Did he have any
facial
fractures?
So these are the bones that constitute the face. So if you have a facial fracture, you go to your left. If you have no facial fracture, you go to the right. So if you have some event, no mandible fracture, no facial fracture, what they've indicated that is predominantly associated with falls and not assaults.
Thank you.
You're welcome.
In addition, did you do any further study on the force of a person falling back and landing on their head?
Oops, I did.
Could you
So what I did was I did what are called drop tests. I took an anthropomorphic test device, ATD, was just a fancy name for a crash test dummy, and dropped it backwards onto a hard surface to look at what happens if you were to, say, fall backwards and hit your head onto a hard surface. So on this particular photograph of Mr. O'Keefe in the upper left,
This is kind of a
there's
joke.
noted
Come
to be
on, man.
abrasions above the fracture line in the area. You can't see that at all. You can see.
So I'm going to let him finish. But we're saying this dude got hit holding a glass with his arm like this, got spun around as the car was backing into him at 20 something miles per hour. And then he just perfectly fell back and, and hit the back of his head.
Stop the cap.
Dr. Welcher. Really? I'll let him finish. Thank you, Kel. The Honorable Kel Bell said it, but no one is going to just fall backwards without trying to break the fall with his arms or hands. Yeah, so he's saying John just got hit. Boom. Didn't suffer concussion because there's nothing to show that he hit the front of his head on the car as he was initially hit at 75% throttle. He got spun around and then he fell perfectly back on the back of his head on a hard surface. Dude. Dr. Welcher, come on now.
There'd be abrasions right here. Your Honor, I brought a hat. That was the one I used in my testing. May I put it on and demonstrate something?
Mr. Lessie,
If you would like a sidebar, or I can.
are you objecting?
I am objecting.
That's a stage. No, you can't put it on.
Okay. So
This is amazing.
I will show you the dummy testing I did. Watch when the shoulders hit the ground and the head hits the ground. It creates kind of an arc path that will drag and slide objects up the head. So if you have something such as a baseball hat, it'll cause it to drag across the scalp, dragging it up to a similar location to where these abrasions are. So here's the testing. Again, this is a crash test dummies you see on television. This is myself. Be giving me similar instructions, telling them what we're going to do. I said, and watch. Shoulders come in, then the head contacts the ground. What you see is if you fall backwards and land on a very hard surface or hard surface, you'll get extremely high loads on the head. If you compare that to data in the science.
I'm sorry to interrupt.
Yeah.
That, please explain what the chart is before you explain.
Oh, sure. This chart up here?
Nope, on the next page.
Right.
You can largely tell us what it is before you get into the details.
Absolutely.
I swear,
So
if they
this is
drop
actually kind of a
this
famous study that was
crash
published, one of
dummy
the first
straight
studies
back,
looking at head fracture
I'ma
or
lose it.
skull fracture tolerances. So what you see, the portion at the back of your skull is called the occiput bone. So that bone, if you put your hand in the back of your head, is your occiput. So we're looking at occiput impacts. And what you can see is that when they took cadaver skulls and dropped them from as low as 40 inches onto a hard surface, they were getting linear fractures. And you can see even at 40 inches, there was called a stellate fracture. Stellate means star-like. You get a fracture that goes out like a star. So even at a 40-inch drop height, you have sufficient force when landing on a hard surface to cause skull fracture and a level 3 type skull fracture. So Mr. O'Keefe, again, is 73 inches tall. His occiput is about 4.6 inches down from the top of his skull. That means it would fall a total of about 73 minus 5 would be 68. So just under 6 feet. So 72, 4 inches under, so 5 foot, 8 inches is the fall height. What is data showing that even at a fall height as low as 40 inches onto a hard surface, you can get fairly severe skull fractures.
All right, how did it play out, Doc? So what's he gonna say? He got hit, boom, he got hit by the car, he spun around, and then he stood there like Mortal Kombat and just way back and forth, and then fell back. What happened? I want to hear it, Doc. Come on now.
Did you come to a conclusion, to a reasonable degree of engineering certainty, whether or not the defendant's Lexus collided
Y'all are funny in the chat.
John O'Keefe on the evening
Good morning, gang.
of January Exactly, January 29, 2022, around 12:32 a.m.
Yes.
Before you give me your opinion, I'd like you to share with the jury what that opinion is based on.
Sure. So based on the 130 slides you've seen, based on my personal inspection of the Lexus, the correlation of the text stream data with the infotainment data, as well as Mr. O'Keefe's cell phone data, it's looking at, I guess, where the taillight wasn't broken. It's looking at the physical evidence at the scene in terms of taillight fragments, glass fragments, red color in the snow. We have the cell phone data, the location and position of the arm lacerations, the air temperature at the time indicative of sufficient to freeze, the location of the fracture on the back of his head relative to the scientific literature, my testing of forces available falling onto a hard surface, published science on the fracture forces associated with falls.
I cannot wait for Alessi to cook this BS science. Jesus.
I'm sorry, I'm reading from my report. I'm reading from my report.
Can you answer without reading from your report?
No, because it's all BS.
Stop the
No
cap.
objection, Mr. Alessi?
Yes. Object.
So, you're not to read, don't read from your report.
Okay.
Okay, Dr. Welcher, let me ask you again. Based on your analysis, data
It's
available,
garbage,
reviews,
man.
study, based on the fact that you are an accident reconstructionist and a biomedical engineer, have you reached an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus struck Mr. John O'Keefe on January 29, 2022, around 12:32 a.m.?
Yes.
And could you share the bases of your opinion before I ask you your ultimate opinion?
Sure. So again, you've seen my slide presentation. I've inspected the Lexus. I've looked at where it wasn't damaged. I've inspected the taillight. I got an exemplar Lexus. I ran lower speed contacts to verify that the injury pattern and location on the arm is consistent with the height and orientation of the taillight.
Yeah, exactly. Y'all said don't forget that he supposedly flew 20 feet into the air. And didn't they say his shoes got knocked off? Come on, man. Jeez.
I have looked at fracture tolerance data for falling backwards onto hard surfaces. I've looked at the metrics of where his injuries were and what
360
injuries he
circle,
didn't
then
sustain.
20 feet.
I've looked at the cell
30
phone
feet in
data,
the air.
and then I've looked at Miss Reed's
Crazy.
interviews as well.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering certainty
No, we haven't even got to
about
cross
whether
yet.
the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Going to allow.
Objection, Your Honor. Let him answer. Yeah, answer
Yes,
it.
based on the
Yeah, you're a freaking idiot. Ah, I'm so angry. Oh, my goodness. We heard from an amazing medical examiner that said there is nothing that she saw when it comes to injuries that John O'Keefe sustained that point to him being hit by a vehicle. So, we had a very well-educated doctor, one of my favorite witnesses so far, that was on the stand and said, I don't know if this person was hit by a vehicle. I'm not seeing anything that shows that. Now, we have this man, a biomedical engineer, who's relying on the report of somebody who misrepresented their education and has zero credibility when it comes to this trial. And this man with his blue paint and his PhD wants us to believe that John O'Keefe was struck by a car. Disregard all the testimony that we've heard. We're going to believe this guy, Mr. Aperture, who's going to end up, as y'all have said, changing the name of his company after this because of the shame that's been brought to Aperture from this trial. I have no words. Not only that, but he's saying that Karen Reed pressed the throttle down at 75%, was going 20 something miles per hour and hit him. Then he somehow just fell back. I want to see what they're showing with this reconstruction of him falling and hitting his head after he got hit and broke the glass at 23 miles an hour.
On January 29, 2022, around 12:32
I'm not okay. This is disgusting.
I can answer.
I'm not good.
Yes,
I'm not okay.
Based
Good
on the
morning, y'all.
totality of the evidence,
Thank you, Libby.
DNA, everything I've talked about, that is consistent with that happening with a reasonable degree of scientific certainty. That is what happened.
Objection, move to strike, Your Honor.
So I'm going to strike that. I'm going to see Council Zappa for just.
Oh, this is stressing me out. This is stressing me out. This is stressing me out. Why is this guy here?
We'll see you at 10 o'clock. The court officers will tell you about your specific directions.
Oh my gosh. Because he took some biology classes in college. So we're gonna believe this guy over a medical examiner?
It's okay. I mean, I came in early this morning and set up.
Welcome. I mean, we don't really.
I'm never gonna find myself on this side of the law. I'll be an expert witness. I'll be on the jury. Oh, shout out to Officer Token. I see you over there, sister. I cannot. This is
Dr. Welcher,
so
Dr. Welcher can
disgusting.
step down. I know he has to come back and have his
So
equipment.
just leave everything here.
And then you'll come back in 5 minutes.
Roger.
All right. Yes, please. All right, so Mr. Alessi, I will hear you as to your objection.
And he said handsome text. Oh man.
Thank you, Your Honor. Would you like me to go to the
Said I'm
Right there's
beautiful.
fine, and let's try and wrap this all up by
Thank
4
y'all.
because I've already heard you at sidebar. That means both of you I'll hear from within the next 5 minutes. Go ahead, Mr. Alessi.
Thank you, Your Honor.
Amy's
Point number one is the question of whether, based upon a reasonable degree of scientific or engineering certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time equivalent. So,
Talk to him.
by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain event, that is the ultimate question for the jury. That question.
Hold on a second. Hold on. I gotta clip this because this I have a feeling Alessi is about to go in here. So let me rewind this back a little bit because I'm so sick of this Dr. Welcher. I gave him a chance. I gave Dr. Welcher a chance to paint the picture for us, pun intended, right? To show us exactly what he thinks happened. And at the end of the day, this is just BS.
Stop the cap.
It doesn't make sense. If this man got hit this hard, Karen was going that fast, but he only sustained some scratches, and then somehow he magically was still standing and then just fell and hit the back of his head. I can't see it. So Alessi's going to break down the issue he has here. I can't do this. I can't do this with this guy.
Thank you, Your Honor.
Break it down, Alessi. This is
Right there's
disgusting.
fine, and let's try and wrap this all up by 4 because I've already heard you at sidebar. That means both of you I'll hear from within the next 5 minutes. Go ahead, Mr. Lessie.
Thank you, Your Honor. The point number one is the question of whether, based on a reasonable degree of scientific or engineering certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time in equivalent. So, by analogy, if the issue is whether or not a defendant has
The jury has to see it.
and caused a certain event, that is the ultimate question for the jury. That question is never permissible in a trial. By analogy, this is the exact analogous situation. The question of whether there was a collision is the ultimate question for the jury. That is why we are having this trial. The defense
Exactly.
strongly asserts there was no collision, and there is substantial evidence to that. We are going to
Yes.
cross-examine Dr. Welcher. We are going to put in our own strong case to demonstrate no collision occurred. That's no surprise. It was in our opening statement. This witness cannot, by precedent for years, opine on the ultimate question that is going to the jury. I accept, subject to evidentiary issues, the two questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And is the
It's not.
injuries to the individual consistent with being hit by a motor vehicle? Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial where that is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All right, Mr. Brennan.
Very well
So what
said.
Mr. Lisi is arguing is that in their opening statement, they repeatedly invaded the province of the jury because they must have asserted vehemently over and over again there was
No,
no
here we go.
collision. Over and over and over again. And he just told you that when his expert takes the stand, they'll have abundant evidence that there was no collision.
Correct.
This case is about the collision, but that is not the ultimate issue. The ultimate issue is manslaughter or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law.
But they do get to question what an expert witness can testify to. And that's the problem here, Mr. Brennan. Listen, I've supported a lot of the prosecution's witness. But in this case, this man cannot speak to that. We've already heard from the medical examiner. We've heard from Dr. Wolf. This guy who took a biology class should not be speaking on that part. Stop it.
Or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have no jurisdiction or jurisprudence to say what we are limited to. He's entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's not whether or not there's damage to the car or Lexus. That evidence is obvious. He also is an enormous part of a biomedical engineer and an accident reconstructionist. He studied the tech stream data. They didn't. He did. And he's entitled to give an opinion. The tech stream data, based on fact and science,
Has nothing to no.
tells us when, if you put it together with other evidence,
No, it doesn't.
and where, when you contribute it with other evidence, this collision actually occurred. We don't have to play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her Lexus in front of Fairview Road.
No, it doesn't, because they're two totally unrelated factors. And that's what Alessi is saying. Like, you can't read.
Not interjecting the defendant. I always refer to her car, so it is sanitized, her Lexus. I've been careful about that. I don't have to, but I'm very careful about it. He is relying on the tech stream data, the physical evidence, his independent studies. He is allowed
It's
to have
BS.
an opinion about whether the injuries are consistent with the damage to the car, whether the damage to the car is consistent with the injury to Mr. O'Keefe, and he's also allowed to answer, in his opinion, the issue of a collision. Putting aside the fact that that was emphasized and repeated in the opening statement, and it's going to happen again when other people testify. It's not our fault that ARCA didn't testify or look into the text stream data or they don't have an expert for it. It doesn't belittle or limit that evidence. We expect to ask Dr. Welcher.
Nobody cares
to give an
about the
opinion
text
to
stream data.
Engineering certainty, whether the defendant's Lexus collided with Mr. O'Keefe on January 29, 2022, around 12:32 a.m. That is one of the opinions we're going to ask him. Nothing to do with the ultimate opinion of guilt or innocence, or whether it's manslaughter or there's mens rea for second-degree murder.
And what was your second? You said that's one of the opinions you're going to ask him. What else are you
I
looking
will
at?
also ask him about the consistent with, whether the injuries are consistent with.
With what?
I'm going to ask him after this part about the difference between a clip or a side swipe as opposed to a full-on injury, pedestrian collision from a front or back of a bumper, and there are further slides
BS.
to emphasize that point. And so there'll be an opinion regarding that as well.
And you,
Specifically with a side swipe or a clip.
okay, so this is not the end of Dr.
Thank you,
Welcher's
Karen.
testimony. He's just moving on to another area.
It's close, but it's not the end.
Okay. Go ahead. Yeah.
Your Honor, here's a case. Attorney Brennan said, go to case law, here it is. Commonwealth v. Coleman, 366 Mass 705.
Disgusting.
And it stands for the proposition exactly that I articulated. I won't repeat it. Secondly, Your Honor, we practice what we preach. I have the ARCA report right in front of me, and I have the report of...
Is that a new one or is that a...
This is the new one.
Okay.
It's also, the old one is the same. So I can, either one is the same. They do not, Mr. Brennan incorrectly said what our experts are going to do. I don't know why he did that, because he has these in writing. Neither Dr. Wolf or Dr. Rentschler talk about a collision, a conclusion. It's consistency. It's those two questions I said at sidebar. And for reference, Your Honor, for the most recent is page 15. There is no...
I don't have that report, so I'd like a copy of that report.
Your Honor, a copy, and I also, Your Honor, refer Your Honor to ARCA's existing report, which I'm going to do from memory. I think it's February of 2024 that was done for the U.S. Department of Justice and FBI, where they basically said and gave opinions on those two items I spoke to you at sidebar. So Attorney Brennan is incorrect when he says what our experts are going to say or not. We've already committed in writing to what they're going to say. We're consistent. We practice what we preach.
All right, so we will discuss this tomorrow before we start. I'll tell you my ruling tomorrow before we start. I need to go back and see what exactly came in to evidence today. All right, so I'll see you in the morning.
All right.
All right, all rise for the court. There it is, y'all. Let me know what you think about that BS. I'm so sick. I'm done with Dr. Welcher. I'm out. We can throw this witness away and move on to the next one. As a juror, I'm not buying it. I'm not seeing it. I think this whole accident reconstruction is based on so many factors that aren't taken into account in his study. Seeing the text stream data, fine. I've got that. Being able to look at when an incident occurred, okay, that's good. But saying the windshield was cracked, these are the scratches that happened. This person was going backwards at 23 miles an hour, 75% throttle. And this was the result of that from him being clipped. We're going to see if Judge Bev is going to allow it in. Y'all let me know what you think about this in the comments in the chat. I can't do it, man. I can't do it. Let me read some of these super chats. Amy said she's putting in place a handsome tax. Oh my gosh. That's brutal in here. Libby 22 SC girl is up in here with the 10 bomb. Thank you so much, Libby. She says, Amy, I hope you feel better soon. Thank you so much. I can go find him and kick his you know what. Oh, we got it taken care of, Libby. Don't worry. ClassE to the most handsome man on YouTube. Oh, goodness. I love y'all and I love my CEB family. Shout out to Libby again, always showing support. Y'all better stop gassing me up, man. I can't take the compliments. It's painful. Thank you, Libby. Melissa B is in here, became a new member. Welcome to the member side, Melissa B. Make sure you check out all the members only content and enjoy the time over here. We appreciate you being here. My dog, Mr. Brown's in here with the 10 bomb, just showing some love. He didn't even say anything. Shout out to Mr. Brown. Appreciate you, man. Praying for you. And I hope you're having a speedy recovery. Rest up, man, and make sure you get that PT in. All right. We want to keep you around here for a long time. So make sure you're taking care of yourself. You only get one. You only get one life. And then we've got Kara Hampton in here with the 5-bomb. She says, to the most handsome YouTube host out there. Amy, love you, lady. Taxes paid. Shout out to Kara Hampton for paying her handsome tax. Is this really going to be a thing? I can't take it, y'all. I'm a super low-key type of person. I know I'm on YouTube. You wouldn't think so. But y'all can't be paying handsome tax every day. Y'all, man, I'm a change. I'm a change. Y'all keep showering all these compliments on me. I'm going to be a different person. I can't handle it. Shout out to Amy for starting the handsome tax. All right, let's go ahead and get into day 22 officially. I think they started. I want to see what Judge Bev's ruling was about that whole conversation we just saw go down. So let's go here, do this. All right, and we're going to rewind a little bit so I can catch what she says. Hold on a second. We should have a little bit of delay today. Hopefully it doesn't jump ahead on us. Oh, it's muted, of course. So what is she going to decide?
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m.
Fine.
Because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe, because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so the jurors are lining up.
Approve.
We should have them momentarily.
It's fine. I see.
Okay.
I can see what Bev is saying, but in my opinion...
Is Dr. Welcher right around? Yes. Why don't we bring him in if he's here before the jurors?
I don't want to talk over her. In my opinion, it's not going to make a difference. I think the jury can see what's going on here and how there's so much reasonable doubt or speculation. Oh, shout out to the Honorable. You got to call her the Honorable now. Officer Token, the one black lady in all of Boston, is in the building. Shout out to her. Either way, I don't think it's going to make a difference to the jury.
We provided a copy to the defense.
I'm not buying it.
All the,
next witness.
Redactions.
Okay.
I agree.
Are you in agreement with this, Mr. Alessi?
I haven't gone through it, but I have no reason to believe that I wouldn't be in agreement. So
Okay.
I can just go with it.
There is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude, and that is in that version. I didn't want to pull it out with the court's order, but I'll talk to.
Do you know the number? You don't have to find it if you don't.
It's 131.
Oh, is this was it 130? Was it 131 yesterday too?
It was.
So at sidebar, I said we could go back to that, and Mr. Alessi agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132. That was my understanding at sidebar.
It is, but subject to me being able to object. I was basically, because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at it again. That's not my understanding, Mr. Alessi. It was you were concerned just about the heading, and then I said we'd go back to both slides.
Oh, yeah, no, I'm okay with that.
Yeah.
That one, yes, Your Honor's recollection is correct.
Yeah,
I'm okay with the heading removed.
And we were going to start on that, but you thought because I struck it based on the objection, but then it's sidebar, I said we could go back to that. That's your understanding too?
Correct, Your Honor.
And I'm sure that Dr. Welcher took off the heading on 131.
I think he did, but because I think he took off from 124 to 1.
I think he did as well.
I did.
Thank you very much.
Okay.
I would like your prediction to come true.
Are they out there, Paul? Okay, thank you.
Rise to the jury.
Amy said, I think of fruit snacks or grape juice when I hear his name. Dr. Welcher. Do I have some right here? Can y'all see this? Shout out to Dr. Welchers. Oh man. Dr. Welch is in the building.
Yea. All persons having any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
All right, good morning again, counsel. Good morning again, Ms. Reed. Good morning, Dr. Welcher.
Good morning, Your Honor.
And good morning, jurors. I have to ask you those same 3 questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Good morning now.
Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you very much.
Man.
All right, Mr. Brennan.
Thank you, Your Honor.
Amy knew I had those in the drawer. We need to get the cross-examination so we can end this guy.
Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you 2 other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114, 115.
I don't want to see this.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. What? There we go. Could you go back one, please?
Yes, man.
Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is...
Oh, could you take that down, Dr. Welcher?
Thank you, Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you,
So we need to take this slide down.
Sorry,
you could take the PowerPoint down, please.
that was in a different spot on the slide. Hold on a second.
Right, that's better.
Thank you. Sir, I had asked you yesterday about some of your opinions. I
Correct.
want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if he's reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
no, I am counting on my fingers.
Thank you.
So I am counting on my fingers.
He was wearing the sweatshirt.
Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I needed the same type of shoes, my exemplar inspection.
I see what you guys are saying. That's a great question. Wasn't John wearing the sweatshirt while he was hit? Why are we seeing blue paint on his arm and a t-shirt? Got him. Great point. You guys are so smart.
Where I matched up the heights, the locations of
He
the
was wearing the
lacerations,
sweatshirt later, but not
and
during
then
the
the
paint
text
test.
stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information.
I can't type, Chris.
Do
Happy
you have
birthday,
an
man.
opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022
Objection.
at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
And do you have an opinion whether, based on the data,
This is so frustrating. Based on what information is he saying that a glass could have been thrown? Jesus. Oh my gosh, guys, I can't do this. I can't. So he's saying his two theories are somebody threw a glass at the taillight and it broke, or if you're going 8 miles an hour and it hits your arm, then it possibly could have broken the taillight. What type of BS is this? Oh, we got to get to cross. I'm going to have to control myself and not stop. We got to get to cross-examination of this science, because this is, I've never seen anything like this. I mean, a reindeer could have flown by. Was it, what time of the year was it? A reindeer could have flown by and clipped it with their antlers. It's possible. It's possible there could have been a second glass somebody threw at the car. It's possible. It's possible a rock could have flew up while Karen was backing out of the driveway at 50 miles an hour and broke the taillight. It's possible that when she backed into John's car, which he testified to that she did and recreated the whole scene, that maybe it jolted the rest of the car a little bit. And then at a later date, she bumped into something else and it was cracked and was broken. Oh man,
And based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe.
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32
how long is
a.m.?
this freaking
With that caveat,
driveway?
yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
How can he testify to this?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And is that specifically pertaining to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
So basically his testimony is, hey guys, whatever you think happened, yeah, it looks like it could have happened. That's his testimony. Oh, you guys think he fell on the hard surface? Yeah, it could happen. You guys think he got hit by a Lexus? Could happen. So now that they've opened this door, oh, I pray to God. I pray, Alessi, please ask this man, since he's such a great accident reconstructionist, if it's possible that John could have been in the house and fallen and hit his head, and that could have caused that injury. Is it possible John could have been standing there and was feeling drunk and blacked out and just fell backwards? Is it possible, Mr. Accident Reconstructionist, that John was hit from the front, fell back, and sustained that type of damage? Since you're a medical examiner now, Mr. Biomedical Engineer, what do you think about that? Is that possible, or is it only possible that what the prosecution think happened?
To finish, I'd like to ask you a few more questions. You've written some papers on
This is garbage.
side swipe collisions.
I can't,
or
Libby. I
clipping.
got people
Can you
working next to me.
describe
I
to the
can't mute
jury
and screen.
explain what a side
I'll scare
swipe
them.
collision is, or a clipping, and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you're going to have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about
I'm not gonna
potential
make it,
damage
guys.
to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted.
It's difficult.
Without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult
in the building. Welcome.
To determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in obtaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible.
So many variables.
Will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper as opposed to side swipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Actual Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
Oh, this
I'd ask
guy.
you to turn to slide 139, please.
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this
More
was
BS.
a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had this is a image from the police report. Well, let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, sure.
Do you want that expanded like other times?
Enlarge it.
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure, John. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury, so no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Okay.
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a side swipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your
pleasure.
Honor, I would move into evidence subject to redactions, Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson, with that
That is, Your
caveat.
Honor, thank you.
Jimmy. Thank you. Putting in both the flash drive and the notebook.
On representation, it's consistent with it is the same as that I know.
So let's put them both together now and decide later,
Thank
okay?
you.
Those two slides are incorrect on the flash drive.
Yeah,
Okay, so we'll switch that.
that was.
Thank you. Yes. What exhibit number is it? 206, thank you.
Exhibits 206, A and B.
All right, Mr. Alessi, whenever you are ready.
Your Honor, if I could have a moment to set up.
Sure.
Yeah. Here we go. It's finally time. Dr. Alessi is going to cross-examine Dr. Welcher. This is about to be crazy. I'm ready for it. We gotta skip ahead. We need to. I can't wait anymore. Shout out to Officer Token, the one black female. In
Morning,
Boston.
Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you.
Asserting his dominance. Oh boy, this is not gonna go good.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay,
yes.
yes, certainly for the court of law, yes.
It ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay.
Yes.
And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes.
Are they going to
again,
bring
can be
up
subjective.
Shannon?
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you
Scientific
used
certainty.
the word sometimes to reasonable degree of scientific certainty?
I may have.
Right. So
You did.
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now, you simply follow the data.
We'll see.
Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay, so
Here we go.
in terms of you've agreed that you apply the scientific method, so I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah, so would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem,
Here we go.
the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial, or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I
Yeah,
was
sounds like it.
talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
So
sorry, sir, to interrupt you.
I need to.
Go ahead and answer your question.
You're
He's not
asked
answering
peer
the question.
reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you use here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application,
Answer the question,
yes.
doctor.
That was my question, just the methodology. Thank you.
Yes.
You're welcome.
Thank you.
Now, the scientific method
him down,
that
Leslie.
you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So, are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane.
What does that mean, Doc?
I'm not an expert on cognitive.
He
I
said
can
stay
talk to
in
you about
his lane.
confirmational bias, if
Fair.
you like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury, is how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you...
So hold on a second.
Okay, I'm sorry.
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question, sir. I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct, but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
Did you do
I
that?
generally have many working hypotheses as I'm working on the case, and then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree
He's
that
dancing around those questions.
the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence,
See, he's got to ask it a different way.
The number of questions.
Maybe I can, just this last question, and make it
He needs to
clear
ask it
for
a
you,
different
sir.
way. Yeah.
You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses. You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
Thank you. Good job, Alessi.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence.
Come on,
yes.
dude. Jeez.
And when you test those hypotheses, isn't it often the case that, particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
Good question.
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this. Isn't it the case that when you have multiple hypotheses,
Well, hypotheses.
the one that most, out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury. Is that a fair statement?
He is, Kelbell. Kelbell said he's
I
trying
think
hard to
generally,
outthink him.
Again,
I
I
agree.
it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
Yeah, unless he just needs to ask a more direct question about this case. And I think that'll help.
fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes,
He's
sir.
taking notes too. Yep.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So
Here we go.
what I'd like to do now is switch
We're switching the topic.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know...
I'm familiar with his reports. I don't know the man.
Okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by
Trooper Paul.
lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is it the date, January 29th of 2022, is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when, the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Correct.
So
Actually, I might be able to find out if you'd like me to look.
it's,
It doesn't
it's
matter.
not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right,
I would
so-
want to double check.
That's 2.5
Come on, Doc.
years from the date of the incident in question, if I did the math right, correct?
Oh, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct?
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
we're
you
an
would-
engineering company. We bill for our time. So
As you should.
So
Get your money.
you know that Aperture is getting paid for its work in this case, correct?
we are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir,
Come
you are
on,
a senior
bro.
vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
Yes.
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly.
What?
So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that
my
discussion and just go
gosh.
right to the billing.
Come on, man.
You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are
Your
you-
knowledge. To your
So
knowledge,
is your
sir.
testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign.
There you go.
So
Good
I'm
job.
aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Why do these witnesses
it's a legal
do this?
obligation of the Commonwealth. Your firm does work, and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is
Well, he's
we
a
paid for the
dumb
Lexus.
businessman if that's the
We're
case.
keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That's
Oh,
where
my.
I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The
it's-
obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it
Good.
the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000, and is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
But the second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates. You said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
Yep.
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it
It's just embarrassing to me that this guy gave all of these details about his education, his 30 plus years of experience, all the things that he's done. And then we can get to this point of simple questioning about billing, and he looks like a freaking idiot. Why is that? Because he has a bias. Why is that? Because he has a motive for being here. It's not that hard, doctor. Do you know if you got paid? Yes. How much have you gotten paid? $300,000+. Okay, cool. When did they start paying you? Well, I don't know. The first trial back in September. I don't know. I wasn't there. I have no idea. Okay, cool, doctor. Let's keep it moving. He's looking super stupid right now, like a bad businessman, because he's trying to fit into a certain narrative. Don't do this, man. As a witness, why do you do this? Psychologically, I want to know from some of our attorneys in here, from a psychological standpoint, the jury sees this and they see this man is clearly being difficult with the defense attorney. How does this look to the jury? As a juror, it looks to me like he's trying to hide something. He doesn't want to say something. But is there a part of it to where this is good for the prosecution because maybe they make the defense look difficult? I don't know. I just don't get this tactic. I don't get why these witnesses act this way once they get on the stand. Maybe it's because of conversations and bad coaching by the Commonwealth, but this is just, it's hard to watch.
refresh your recollection is to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I put you on it?
Yes.
May I put you?
Yes.
Thank you. Sir, may I ask you?
Yeah, could you direct me so we're not wasting time?
Well, it's your, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
The Honorable Kel Bell says, I do preparation with my witnesses to simply answer questions like this because it looks worse when they try to be difficult. Juries do not like this. We had to sit here for a freaking day and some change to listen to him pontificate about what might have happened to John O'Keefe. And we sat there through this. And now you're getting asked simple questions about whether you know if you got paid or not, when every single employee of every company knows every time they get a paycheck if they got paid. And you're a chief executive in your own company. Stop it. Kel Bell says, I do preparation with my witnesses to simply answer questions like this because it looks worse when they try to be difficult. Juries do not like this. As a juror, I hate this. Can we just answer the questions and move on, sir? Let's get to the point. Is it crazy?
And then when he's done, Mr. Lessie, you can take it back to the podium.
Yes, Your Honor.
Crazy. Aperture needs to rebrand after this because this is garbage. I cannot stand this.
Can I have a few more questions before I do that, Your Honor, for foundation
All right.
Would you like me to start with
So-
refresh?
Go ahead and start with refresh. Go back to the podium, please.
Sure, yeah.
Thank you.
Thank you, Connor.
She said, "Get your ass over there."
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
Oh my
So are
God.
you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall
Big
it?
money.
May I approach, Your Honor?
Okay.
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful.
Please.
You said please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right. And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
Dog in the fight.
Misquoted me. I don't have any dog in the fight.
Of
You don't
course
have
he
any
was going to
dog in
correct
the
him.
fight.
Correct.
Thank you. Now, switching topics,
Okay.
All right, so we're switching. Let me know what y'all think about that
you
first one.
submitted an updated PowerPoint presentation,
Sorry, guys.
the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you
Of
know
course
when
not.
the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
Great
Don't
question.
know.
He doesn't know anything. Why do they want to look stupid like this? Why do he want to look?
know when?
Hold on one second. Dr. Welcher, I'd ask that you not do
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
Stop cheating.
Thank you.
You're welcome.
If I may, Your Honor,
Yes.
continue.
I'm with you.
Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see counsel at sidebar while you pull that up,
Thank you,
please.
Your
Oh, we got our first sidebar. And we're going to skip through it because we have some delay. This is, why did she ask them to come to sidebar?
Last.
Here
I'm
we go.
going to
Keep your
Welcher, what I'm
computers
going
close,
to
sir.
ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
Yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the.
She wanted to. That's smart. Shout out to Judge Beth
Thank
for
you.
calling that
All
out.
right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
Answer the question, doctor.
If you can just hear my question, it's this.
What's up, Monty?
The version of the presentation that you put on the screen,
Close your freaking computer.
when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay,
Okay,
good.
great.
Now,
Answer the question.
The
Thank you.
version before
Jesus.
that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's
You
my
just-
question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025,
Which is
you changed your PowerPoint presentation
2024.
during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Great. So you created on January 30th, 2025. You made your...
13th.
Pardon me?
Oh, no, oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right. If I could finish my question, and I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half. that
Sure,
you
there was
didn't
two
state.
changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from,
Of course he did.
because they were saying I didn't provide everything, and I had provided everything.
All right, so
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this.
Please.
And if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear, it was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
Because I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide,
care.
I added one line to the bottom of the previous slide.
Nice.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So, A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that
So
I
it's
gave the way
accuracy,
she
not
could drive, I
significance.
gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the
Hold on,
clip.
Dr. Welcher, I have to ask you
Oh, I'm
not to
sorry.
refer to that.
I'm trying
So
to be helpful.
close your
Yep,
computer
let me
and-
close it. Sorry. I was trying to answer his question.
So I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just flat. Thank you.
Thank you, Your Honor. So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
Here we go.
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
Of course. Yeah. It's like, hey, we heard that Karen might have been angry. Want to see this text message? That might help with your analysis. Get out of here. Good God. Come on, man. Karen and John were fighting the night before.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting
not Shannon.
report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right, and so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed, it's just it was pointed out to him that that should be looked at? What's the basis of your understanding that he found new information?
Objection to the question.
I'm going to allow the question, but you have to ask it differently. Mr.
I will,
Burgess.
Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting and our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether, in fact, it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an
It's
amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where
He don't recall.
or Aperture
Bring out Lil Woody.
submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, sir. Can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
Come on.
You're
Ah,
welcome.
Mr. Alessi, is this a good time for a break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay.
we taking
All
a
right, folks,
break.
why don't we take our morning recess?
Woo, it was getting too hot in there for Judge Bev.
Love to use the restroom.
Let me read some super chats and see what y'all think about this. Finally, it's all making sense. It's all adding up. What are y'all saying in here? Oh man, shout out to Cynthia Hartz in here with the 5 bomb. Says my handsome tax. All right. Good morning, Classy. Good morning to you, Cynthia, and thank you for being here. I appreciate the love. Also, let me see. We have someone over on the Cash App. Oh, shout out to Donna in the building. I appreciate you with the 5 bomb from Fayetteville, North Carolina. Thank you, Don. What do y'all think about this testimony and, well, this cross-examination so far? Amy said, this guy is a clown. Do you know? Did you get paid? I don't know. How long has this case been going on? Well, I've only been on this case for 8 months. Yo, this is bad. They're taking a break and we're going to skip through it because we've got some delay. But this is embarrassing. Aperture must be a clown business. I mean, these guys are making themselves look bad at this point. Just answer the questions and we wouldn't even have this conversation. Oh, he about to lose his job. He's not going anywhere. It's his company, which is why it's hilarious. He said, I don't know if we get paid for this. Ain't he the senior VP? Yep. So you took a liar statement at face value and not your own research? Got it. What? Not to mention that the information changed as he got more evidence from the Commonwealth, which again is not a great look to me either. As a witness, I'm like, okay, so aren't you the professional? Why do you need a clip to help you determine what could have happened? Why don't you take the evidence that's been presented, we've had for 2+ years, and figure it out? Which is fine. I'm not going to get mad at him for getting more evidence, but man. Shout out to Tatum, has been a member for 3 months. Says Dr. Welcher needs some milk. He's weak. He needs some milk for real. That guy, he's up there scraping and scrambling. Let me update this. Oh, so we're taking a break and we're going to get into our next topic. Let's see. Sure. This one was about evidence. We're going to have so many clips of Dr. Welcher coming out because his testimony and cross-examination is wild. Thank y'all for liking the video too. We've got over 1,000 of y'all in the building. 700 of you have liked the video so far. If y'all could take a second and like the video, I would appreciate it. And it's free. Takes less than a second. All right, let's get into it. We already have seen this fool's reaction. There's nothing more to see, really. It's all bunk. Senior VP. They better snatch that title. It's fine. It's not like he's lying on the stand or anything, but geez, dude, can you just answer some basic questions for us and we can keep it moving? We don't have to get stuck on the silliness. Here we go. All right, let's get back into this cross-examination. This is interesting stuff here.
All right, whenever you're ready, Mr. Lessie.
He's telling the Commonwealth what he wants to hear.
Address an administrative matter that I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
It was closed.
Closed, yes.
Would he open?
So did you just turn it off?
No, but I will. I closed it. You want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at sidebar,
Sure.
please.
Oh, that's sidebar number 2. I started my recording too early. We got another sidebar. Fun stuff. Look at Yannetti in there with the haircut. Let me see. All right, y'all give me 1 second. Let me make sure I update this. Oh, I didn't hit the right button. Here we go. And then we'll skip ahead and get back into this testimony.
May I, Your Honor?
Yes.
Thank you.
Lunch
Here
break.
we go.
I know it takes you a while to set up in the morning. I'm going to ask you to take all that down during the lunch break, okay?
Yeah, take that stuff down. We don't want any more issues, sir.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, Are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
Oh,
No.
what's going on here, doctor?
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job, and I opened it up and it was some internet troll.
Sure. I'm asking about emails
Shout out to
from
the
the
trolls.
prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been
There's
scheduling,
Dottie. What's up, Grace?
you know, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
He don't recall.
So there was a communication with the prosecution.
Unless he used the podium.
Might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
I'm going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
Oh, you're not?
asking a question.
So
If it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay. So in order to properly read,
Break it down, Alessi.
the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
I think it was
If
1162,
you
wasn't it?
associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It
Dude,
can. I mean, you need
yes.
to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying...
So are you saying, sir, that the text stream data is unreliable? I hope that's what Alessi asked him.
Mileage, the
Ax 'em.
overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have
Not
to take the
necessarily,
totality
or
of the
no?
data.
Yo, Slim, like
My
this is
question
wild.
is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So, again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Oh my God.
Let me try it a different way.
Or he could answer the
Your
question.
analysis or anyone's analysis in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No.
Oh, so
Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool
He's so smart,
in the
he's
analysis
stupid.
process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could
Thank
go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
What slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events that
Actually,
are...
can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no,
He's going
scroll.
to try and school us.
So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So
But-
to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right.
Good job.
So you are aware that the Commonwealth had maintained up into your firm's engagement that...
Are you saying there's no basis for the question? All right, I'm going to allow the question and
No, nice try.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
Oh, my.
so the objection sustained. You need a foundation, Mr. Lessie.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
So,
Right,
yes.
and did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in
Shout
that
out to Shannon.
analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Come on, man.
Now to the question. Based upon that review, that knowledge, that understanding, that base, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there
course
was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir?
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No.
Yep.
I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report,
Of
correct?
course.
So, you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
Oh, is that 2? 2 or 3? 2 or 3 sidebars. We got more objections here. I love how they take so many sidebars during the defense's turn. Here we go. Don't let him slow you down, Alessi. Keep cooking. How many sidebars is that? 2? That's 3. Thank you, Kara. Goodness.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So just 2 words, just strike theorized.
Okay.
And alleged.
Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your
Hold on, Mr. Alessi. The court reporter can't hear you.
Thank you. I will.
I'll object again to the question that's coming.
He hasn't finished the question.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr. Alessi.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that sentence.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Oh, she said no.
Dr. Welcher. In terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about that.
Oh my gosh. That's number 4. All of our delay is gone. We gotta keep it moving. Hold on. Let's see what we're getting into. What do y'all think the trouble is with this? We got Karen and Yannetti looking at their notes. And let's see if we can get back to the testimony. Unless he's going to get the question in there. There we go.
Excuse me.
All right, y'all give me 1 second.
May I, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank you.
page of his report.
Do you have a paper copy or do you need to?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
You did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge, as you would assess the cables and beams of a bridge, you assessed the human anatomy, you made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
If given sufficient data, yes.
So, you know how to, do you know what
Above all
a
the
force
qualifiers.
calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law
Okay.
is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right. We need to do, we're going to do that, we need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let me know.
You can just leave it right
All
here.
right.
So I just want to get the principles down first. So Newton's second law.
Baby
force equals
steps,
mass
Doc.
times acceleration. And force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force?
That's what we actually measured
Right.
in the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you take, usually acceleration is measured in feet per second squared. If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
We'll get there.
So
Y'all just wait
that
for it.
math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
In that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds, and then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation and that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the... That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Leslie?
I do not have with me a copy of the report he cites in his reference. He did, can I ask another question, Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can
question.
I go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question, and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't
Good.
this
There we
article
go.
also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
No.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979,
You're quoting a sentence.
advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you contest that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Hey, that's about a source.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus, has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way. Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
Sounds like
I don't know it off the top of my head.
All right. The Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion, that was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
No.
So in a way I did, because I said my drop testing shows that you can do this.
Gosh.
So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
Come on, doctor.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough.
That's
We'll
funny.
call it a spoiler.
I don't know how he could determine
You
that.
visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I would use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No. I actually didn't set foot on the property.
I mentioned this question
You
yesterday.
didn't set foot on the property.
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north.
This is
and
interesting.
I guess, or excuse me, slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood
not.
right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did
We scanned all that stuff.
Scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know
Yes
exactly
and
where the
no?
point of impact is, whether he was completely in the road or up on
That came.
the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler and you measured the height, you did all
Absolutely.
that?
Yep,
Where was it? It was you? Was it you in that slide?
it was
Where were your feet?
on the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground, to the top toward the spoiler, and you took a measurement. And you said that that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine.
Unless he's got to get on the
and you
microphone,
said
man.
testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So, the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in
We
your
just know
slide
that he was hit.
yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that.
Yeah, so you don't know
I don't
anything.
have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede
He don't know. Moving on.
that the level of his eye could be non-contacting that fin or spoiler because you don't have information as you just described.
Sure, it could be from contacting the ground. It could be
Fist.
from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration
Thank you for using the mic, Alyssa.
berm, and you didn't mention the berm at all when you were discussing this measurement with the jury yesterday, correct?
That
Correct.
is not correct. You asked me 2 questions. I absolutely considered the berm. And the second question when I presented it to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the
Yep.
snow,
Reasonable
and you
doubt for
mentioned the
sure.
berm, I'm talking about when you did the measurement of whether or not the
about to start
laceration
getting
could be
loud.
caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming
Come on,
like
man.
this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car.
Nice.
I could probably find the slide for you.
So
No, stop looking at your stuff, Doc.
You didn't do a force analysis to determine how much force would be applying, assuming a contact with the right eye, did you?
That's correct.
Goodness.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
Part of what they do.
So I lined up his anthropometry
biomechanist.
relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct.
Yep.
If we had more information.
It's getting ugly.
Mr. Leslie, why don't we break here?
Thank you, Your Honor.
So jurors, your lunch is here. We'll see you in 15.
Did she say 15
Thank you, Your Honor.
or 50?
So jurors, your lunch is here. We'll see you in 15.
Oh, she said 50 minutes. All right. Man, I need another smoke after listening to this dude. How are y'all feeling, man? What do y'all think as a juror? And oh, first of all, super chat. Shout out to Amy with the cake. Oh my goodness. I could use that right now. It is lunchtime. We also, I think I missed somebody over on PayPal. Did I read this one? I did not. Shout out. There it is. Shout out to Slim Life over on the PayPal. She says, handsome tax and beautiful tax for Amy. All right. Love y'all. We appreciate you, Slim Life. Thank you for the continued support as well. Interesting testimony here. It's all BS. It's lunch. Rondon said, I'm out of here. I can't take it. Nice. They provide lunch. Yeah, that's true. It better be good. I wonder what they're having for lunch. Also, shout out to the cameraman giving us a sneak peek into what's going on in the courtroom. If he leans his head down and lifts one, if he leans his head down and lifts one leg and waves his arm in the air, this guy is just stating guesswork and supposition as fact. Yeah, it's bad. Rhonda said he's in trouble, as he should be. Oh, sir, tone down the attitude. Let's check out the charges, the changes of color in his face. He's over his skis. Yeah, I don't know why he's given so much pushback. I think the defense is asking simple and straightforward questions. And because he doesn't like the picture that the defense is trying to take. And you know, we like to say with these witnesses that they're not on trial. But when you're an executive for someone like Aperture, let's be real, you are kind of on trial. And the reason he's probably answering the questions like this, he's thinking about all those contracts. He's thinking about that 300,000 in billables. Sheesh. So even though they're not on trial, they kind of are on trial because things don't go well. They might have a lot to lose. I'm feeling our whole entire judicial system is corrupt. It's tough. It's a tough system to navigate. That's why I stay over on this side. Who looks worse, this guy or Burgess? Definitely Burgess. They made him look like he was completely uncredible. Dr. Welcher's just being difficult. And it's annoying. And I don't think the jury, as the Honorable Attorney Kel Bell stated, is looking at this in a good way. He did the hokey pokey and he turned himself around and then he got smacked in the head by the car. So arrogant. I would be embarrassed to work for Aperture after this. After all this dude is worse than Burgess. Well, at least you know if you work for Aperture, I mean, you got some contracts coming your way. The nerve of this guy to act offended that he's being called out on this. He's being called out on his offensively stupid lying. I butchered that comment, my bad. He's combative and unlikable. She said, your lunch is here. He is twisting his story as fast as the questions fly. I agree. Well, this guy runs the company. He's thinking about Shannon. Yeah, I'm surprised he didn't get an email about Shannon. At least he didn't testify to it. Let's rewind it back because I want to hear the last part of this testimony. Let me see. It wasn't here. It's when we came back from that last sidebar. Yeah. Here we go. Let's go back to right here. because this is important when we start talking about where he got the evidence from, how he came up with his hypothesis or hypotheses. Let me make sure this is the right. Oh yeah, this is it. All right, y'all give me 1 second. I'll be right back.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So just 2 words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your
I'll object again to the question that's coming.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr. Welcher.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that sentence.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about this.
Excuse me. May I, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank you.
page of his report.
Do you have a paper copy or do you need you?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
You did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So, you know how to, do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right. We need to do, we're going to do that, we need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let me know.
You can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force?
That's what we actually measured
Right.
in the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you take, usually acceleration is measured in feet per second squared. if you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in Gs. People often heard about fighter pilots losing consciousness at 6 or 7 Gs, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or Gs as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
In that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds, and then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the... That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Leslie?
I do not have with me a copy of the report he cites in his reference. He did, can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next question.
Can I go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question, and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you contest that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Maybe that's about a source.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus, has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way. Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion, that was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I would use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No. I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler and you measured the height, you did all
Absolutely.
that?
Yep,
Where was it? It was you? Was it you in that slide?
it was
Where were your feet?
on the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground, to the top toward the spoiler, and you took a measurement. And you said that that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So, the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler because you don't have information as you just described. Is
Sure,
that
it could
correct?
be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with the jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question, when I presented it to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car. I could probably find the slide for you.
So you didn't
That's
do
all right, Doc.
a
Just answer the
force
question.
analysis to determine how much force would be applying assuming a contact with the right eye, did you?
That's correct.
I want to go back and see
And
what the
force
medical
analysis
examiner
is what
said.
biomechanists do, correct? That's what a biomechanist
Let me
does.
see what day that was.
That is part of what we
Part
do.
of what they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct. If we had more information.
It's day 16.
Mr. Leslie, why don't we break here?
Thank you, Your Honor.
All right, so we got a little bit of a break also. We got to go back. We're going to do a little bit of rewind. Since this guy thinks he's a medical examiner, let's see what the medical examiner said. Oh, why don't they have day 16? Oh, man. What day would day 16 have been on? I'm going to find this for y'all because I want to ask, excuse me. I want to actually hear from the expert and see what the expert had to say. We've got Buchanan. We've got Yuri. Did the doctor come? The ME come before or after Yuri? It was after. All right, so we need to go back here. Here we go. And then we've got the medical examiner here.
Rise.
Here we go. I'm going to see if I can find it for y'all.
It's NN for identity.
And I'd like to move NN into evidence at this time.
And of course, Alessia was here too.
Right, so you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages in the pancreas are Wisniewski ulcers?
You mean the stomach?
I want to start with the pancreas.
Wisniewski ulcers are, the term is used to describe the gastric hemorrhages.
Right, so I wanted to clarify that.
We got the
Now
sleepy medical examiner. I want to skip ahead and find this exact spot where she starts talking about what happened to John.
Were you aware of statements from the defendant to various media outlets?
See a gray hoodie sweatshirt of Mr. I'd like to turn to, please, the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent. You talked about ecchymosis, you recall that?
Yes,
In medical literature, there's a synonym for ecchymosis. It's sometimes referred to as raccoon eyes. Is that correct?
Oh yeah, here we go.
Ecchymosis doesn't cause a laceration to an eyelid, does it?
no,
Ecchymosis does not cause a laceration to a nose, does it?
there was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose.
Nope.
Correct?
Correct.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Nope.
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So
Here we go.
you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain, from that impacted back of the head, a laceration to the nose, correct?
Correct.
Officer Token in the building.
So if we could, Mr. Wolk, and with Your Honor's permission, publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid. And Dr. Scordi-Bello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it is. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question. Can you state your answer again? Let me that injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Correct.
Bear with me one moment, Your Honor.
I still want to know how Dr. Welcher explains that.
May I approach, Your Honor?
Yes. Show Mr. Brennan.
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation if I could. Dr. Scordi-Bello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
165.
Thank you.
I want to go back. Let me pause this for a second because I also want to go back and see what she said about his arm.
You can
Can we move that down a little bit?
move it
please?
down a little bit. Yeah,
This is
thank you.
important stuff.
You seem to be doing a very good job. Okay. Somehow doesn't want to
Sorry.
work.
That's
Appreciate
not
you,
working
Libby,
well.
Libby and Slim
It's
Life.
projecting here, but not on the actual picture.
Okay. There may be a second pointer.
I can do it here.
Okay, great.
Yeah. So on the right upper medial arm, that would be the inner side of his arm, there was a superficial abrasion. Again, that's a scrape. Then on his right posterior arm and forearm, so not exactly on this aspect of the arm, but on the back side of the arm, which would be in the back of the diagram, there were multiple abrasions, which I described as ranging from 2 to 3 millimeters and up to 7 centimeters. Then, yeah, if you could move the diagram down, please. Again, there is a back to this diagram. I don't know if you could put that on the screen. There we go. So this is now the right side and this is the left. I noted that there were 2 bruises on the back of his right hand. Also a faint scratch on the back of his left hand.
How do you get a scratch on this
And
left hand?
then moving down to the lower extremities or the legs, if you could please show the front. There was a small abrasion, a small scrape on the side of his right knee.
May I approach, Your Honor?
Yes.
Doctor, I'm handing you a photograph. Do you recognize what's in that photograph?
Yes.
What is it?
This is the back of Mr. O'Keefe's right hand, I believe.
Is that a fair and accurate depiction of how his hand appeared when you examined him?
Yes.
Will this is evidence, please?
No objection, Your Honor.
Okay.
Exhibit 158.
She's gonna get to
With the
his
court's
arm here
permission,
in a
I'd
second.
show P647 to the jury. And could you explain, you said there were 2 bruises. Could you point those out for us?
Yes. There's one here and one here.
Did you attempt to assess those, determine whether you could conclude or opine on a cause of those?
No, I did not. Well, I take that back. I'm sorry. So this particular one has 2 small little pinpoint defects in the middle, which emergency personnel tries to get access to a vein for fluids, for intravenous fluids. So,
Right.
but I did not put that in my report. I just described it as a contusion.
Is it common to see that type of coloration where medical personnel put intravenous or other types of support into somebody's hand?
Yes, it's very common for the skin to bruise when someone tries to get access to a blood vessel.
The other coloration that is unrelated to those two small points, would you have a description of what those are?
No.
I'd also like to
All right,
show.
so actually, we're gonna take a break here. I didn't realize this just started. Guess who's back? Y'all are not gonna believe this. We talked about it a little bit earlier. Y'all know
These niggas lacking.
she's back, y'all. Where is she at? We get to see Judge, the Honorable Judge Paige Reese Whitaker is in the building because Damekion Garlington is having his plea hearing. Now, according to Thugger Daily, he said Damekion Garlington is going to take a non-negotiated Alfred plea. All right, let me hit the record so we can get into this. So we've got some more YSL trial updates for y'all. It's breaking news. This is crazy. Right now, Damekion Garlington is taking a plea. He's going to take a non-negotiated Alfred plea. So we're going to get into the story right now. We've got it live streaming and see what Judge Whitaker has to say. You know what time it is. Shout out to Judge Whitaker. Let's get into it. Was not expecting this today. Here we go. I probably spelled this name wrong too. We'll get to see some old faces, some familiar. Oh, look at Miss Hilton. Miss Hilton's in there. You got a body. Who else is going to be up here? Let's skip ahead through some of this. And look, there she is, Judge Paige Reese Whitaker. Oh my goodness.
These niggas lacking.
You know what time it is. Damekion Garlington's walking in. We got his attorneys. I have no idea who they are. But shout out to them either way.
All right, we're on the record in case number 23 SC 183572. This is a sentencing hearing for Mr. Garlington, who entered a guilty plea
Look at Judge Whitaker.
to certain of the counts against him yesterday. Okay, and we're on hold. They need a Zoom link.
Oh, the
We can just
nostalgia.
use
How are
the
y'all
one
feeling?
We're on right now.
Who am I sending it to?
Miss Warlick. And I guess this is. All right. So, we ready? Okay. All right. So, is the state going to go first? And I don't know what the recommendations are at this point. So, if y'all could let me know that as well.
Good morning, Your Honor.
Good morning, Miss Hilton. She's back. It's not morning though.
Garlington. Yesterday, Mr. Johnson pled to count one of this indictment, which is conspiracy to commit the racketeering and corruption organization.
So they got another one for Rico. Dang.
Street gang activity. Count 49, which is aggravated assault, but murder, reducing aggravated assault. Count 50, participation from street gang activity, and count 54, possession of firearm during the commission of felony. Those charges are total exposure of 85 years.
Right.
As you heard yesterday, Mr. Garlington is currently on probation and indicted 15 SC 138894 for crimes associated with the April 28, 2015 drive-by shooting of Adele Avenue Drew Drive. He received a total sentence of 15 years to serve 5 years in confinement. That probation ends on December 27, 2029. The state brings that up, Your Honor, because as a general condition of probation, Mr. Garlington was not to violate any criminal laws. And as a special condition of that probation, he was to have no direct or indirect contact with any YSL members, no contact with any gang members, and no gang-related social media.
All right. And is the state seeking to revoke that probation?
Not at this time, Your Honor. And while we're not here for a probation revocation matter, the state thought it was important for this sentencing court to be aware of what Mr. Garlington was required to do, because he has failed to comply with any of those conditions.
Oh,
Instead,
man.
Mr. Garlington chose to continue to associate with YSL gang members, to include Shannon Stillwell, Kenneth Copeland, Jeffrey Williams, Khalif Adams, Jaden Myrick, Quantavia Greer, and that's the name of few. He then engaged in a conspiracy to attack a rival gang member, Rashawn Bennett, who was
Shout out to
stabbed
Judge
in Wilson
Whitaker.
County Jail. That incident ultimately led to a retaliatory shooting that killed Christian McMiller and Darius Ford, and that murder led to another retaliatory shooting in which the state believes that Mr. Garlington was a part of, which was a retaliatory shooting that killed Mr. Shamel Drinks on March 14, 2022. After Mr. Drinks was murdered, it was Mr. Garlington on his social media post that said, "We got you boys," and this was only hours
Bad.
after the murder. And the state believes that was to indicate that he, along with Shannon Stillwell, avenged their friend's death. And even after that murder, it was Mr. Garlington talking with other gang members over the phone while certain individuals were in custody to get protection for fellow YSL gang member Miles Farley. It is the state deciding its recommendation, Your Honor. The state has taken into consideration a number of different factors. Mr. Garlington's previous criminal history, Mr. Garlington's involvement with the YSL gang from 2015.
I cannot
his
believe we're
continued
watching
involvement
YSL
in
stuff
lawful
still.
probation. And Your Honor,
Wild.
we have certainly taken into consideration the results of the previous trial that we had before Your Honor. Given that, Your Honor, it is the state's recommendation
Y'all don't miss Hilton?
that for count 1, RICO, 20 years to serve in confinement. Count 42, participation in criminal street gang activity, which would be 20 years to serve, concurrent with count 1. Count 49, aggravated assault, 20 years to serve, consecutive, 20 years to serve concurrent with count 42 and count 41. Count 50, participation in criminal street gang activity, 20 years to serve consecutive to count 1, but on probation. Count 54, possession of a firearm during the commission of a felony, 5 years to serve consecutive to count 50, for a total sentence of 45 years to serve, with 20 years in custody. As a special condition of that probation, Your Honor, he needs to have no contact with victims or co-defendants, no criminal street gang activity, no association with criminal street gang members, no firearms or gun replicas, no gang paraphernalia.
Hang on.
If he has not obtained his GED, be in school or gainfully employed,
Interesting.
and any Fourth Amendment waiver, including social media. The state did have, just as some evidence in sentencing, Your Honor, these are items that were presented during the first trial, but some of the social media posts that led
Shout out to the
up
cameraman.
the murder of Mr. Drinks, Your Honor. And I'm showing it to the counselor. And Your Honor, the first 3, Exhibit 1, 2, and 3 are pictures of Mr. Garlington with YSL associates Christian McMiller prior to his death, Your Honor. The third one is Mr. Garlington, you see him with his back, his head towards the camera with previous co-defendant Antonio Sumlin. State exhibit number 4 is a post by Mr. Shannon Stillwell, which was a few days before Shamel Drink's murder, where it said, "Ain't gonna be the only one crying." And then state exhibit 5 is the exhibit that I referenced earlier, which was done only hours after the murder of Shamel Drinks, in which Mr. Garlington posted, "We got y'all boys." Now,
You may. Any objection to those?
no objection.
No objection. Dang.
And Your Honor, we do not have any victim impact statements for this sentencing hearing, and so with that, we conclude the statement.
All right.
And Your Honor, I want to clarify, I did 45 years, served 20 years in confinement with a balance on probation.
Right.
Ooh,
Yeah,
wee,
that's
that's
what I
a lot.
understood it to be. Thank you.
Thank you.
So, according to Thugger Daily and what we just heard, They're recommending 20 years to serve plus 25 years on probation. Ow!
So we were grateful for the negotiations that we were able to get to, at least partially. We couldn't get there on the numbers, but at least we got there on the charge.
Good Lord.
The state's indicated what they took into consideration in making this offer. I guess kind of balancing what we were requesting. But I do want to just run through a little bit of Mr. Garlington's situation and juxtapose it to the other defendants.
Okay. We'll hear it.
As it pertains to the charges here and in the indictment, I don't believe at any point anyone is alleging that he was a leader. And at some point
That's true.
in 2015,
No, Garlington is not out.
on probation, he did cooperate with law enforcement. He gave a statement. They were questioning him about 2 shootings. He thought that they were only asking him about 1, and he did admit to his involvement in that one. His original sentence, I believe, was 10 to 2, and then ultimately he was resentenced to 15 to 5 credit for time served. I do want to point out that that probation violation that led to his revocation wasn't for him committing a new offense.
She's talking so low. He has a probation violation.
Associated with
YSL.
a gang member.
Yeah.
I don't have the case off the top of my head, but the 2024 case, and this was concerning the overly broad terms that pertain to child molester sentences, said that it's overly broad to put that sentence do not have any contact indirect or direct with children, right? I don't know.
Yeah, I think it was more that the condition that said stay away from anywhere that a child might be was overbroad, but I know the case you're talking about.
Yeah, and so same situation here. I believe it might be there, but I want to highlight the most out of there that he was not engaged in committing a criminal offense. He wasn't subsequently charged or anything, and that revocation took place in 2020.
That's
It
fair.
wasn't down for any other incidents until 2022, and that's where I would like to direct the court.
Problem is, Judge Whitaker don't play. Y'all know she does not play. If they say don't be around anybody that's in YSL, don't be around anyone that's in YSL. Or you. So I don't know how gracious she's gonna be here. We'll see.
2022 situation. Of course, here's an overview of the charges. Of course, we're aware of the RICO and what the overacts are. Most of the overacts concern pictures, posts, and conversations amongst friends.
That's true.
Then we turn to the jail incident. During the time of the jail incident, Mr. Garlington was out of custody. There was conversation between Mr. Myers and Mr. Adams. We went through most of this yesterday, so on the Zoom.
Right.
But he didn't, what wasn't necessarily within the text message was there was a confirmation from him saying, oh gosh, did you guys get this done? Or wow. There was no request from him to make it public. Throughout the course of this, we've heard that the gang members seek recognition and acknowledgement, and most of the time they post their wins and whatever is happening. There's no evidence of that, of him seeking to say, hey, post this, let them know that this happened, let them know that I was involved here. He's not bragging about it. There's no evidence of him taking credit for it. And there's no evidence that he paid for it. I think that the state's theory was that he was involved in some sort of payment for this incident to take place. And the evidence just doesn't support that. In fact, from the incident reports from the jail incident, it seemed like they had gotten into an argument, Mr. Myrick and Mr. Bennett, before this happened. Mr. Myrick had been wandering around for a while. I'm attached just a snippet of that. He'd been outside of, they were both in protected custody. He'd been outside the cell, and then at some point Mr. Bennett was let out. Mr. Bennett had time to do his jail, or his video visit in peace, and then some sort of argument ensued, and that's when they got into it.
I wonder what would happen if they had the sentencing and someone from YSL came to visit him or see him when he got out. Something he has no control over. I wonder if they could pick him up and lock him up then. Wouldn't that be wild? If they could come, that would be crazy.
As it pertains to what happened with Drew's case, I'm sure the court heard that. I just want to reiterate just this part.
I remember it.
Okay, no need to play it, Your still, we have no direct evidence of him being at the location. We don't have evidence of him being in the car, so DNA. Not that that's like a big deal, because again, there was very little evidence found in the vehicle to begin with for anyone. There was no evidence that they had planned to do this. And the post that was made after, and I get what the state would like for Mr. Garlington's intent to be behind that post, but it had nothing to do with Mr. Links. I don't think We Got Y'all Boys is just like a general statement of support. They were going to the studio that day. I'm not sure what inside jokes they might have shared. But I just am hesitant about there being other events to infer nefarious intent to a post that's so general in that nature. Of course, the video that Corey is aware of, it doesn't even support, even if there was a reach to put him in the car. It doesn't support. Now, there is enough circumstantial evidence placed in there. There is enough from their FBI situation with the cell phone, but even with that, there's conflicting evidence as to the cell phone tower. At some point, early March, there was a wiretap placed on Mr. Garlington's phone. The FBI compiled this location data based upon his cell phone records. However, the wiretap is getting real-time locations of incidents. So this is what the FBI's looks like, and it's tracking him. The shooting takes place around 10 p.m. So they got his time located from 9:30 up to about 9:59 around here. What's interesting with the cell phone, the wiretap data, is that it shows that he's traveling up I-85, and where his cell phone picks up, it bounces from one tower to the next. Where it ends up is north and I think it's north and east. North of 20, east of 85. And so the incident location takes place west of 85 and south of 20. So then 9:48, it's only pinging up in that direction, which is more indicative of that he was traveling up 85 north separately, whatever, and then came down. And that is consistent with him being found on the highway, not necessarily in that location. That real-time data at no point puts in where the location of the incident was or the gas station. But again, circumstantial evidence can go either way. And so Mr. Garlington was really willing to take the risk on that case to Alfred plea, Your Honor. But I would like the court to consider the sentences of other individuals in this case based upon their leadership role, Mr. Garlington's lack of leadership role, his cooperation with the lack of cooperation with no evidence that he directly harmed anybody in this moment. For a lot of the previous defendants, there was no direct, or maybe there was enough guilty enough there was a presentation of evidence of direct harm, and his prior felony conviction. So what we would ask the court for is a global 40-10, and credit for time served with balance suspended, and how we envision that would be a 20-5 on count 1, credit for time served with balance suspended.
20-5 on count 1.
32, 10 years probation, consecutive, count 1, count 49, 20 years probation, concurrent with count 1,
How many?
20.
Okay, so that's 40.
Count 50, 10 years, probation consecutive, to count 42, and count 54, 5 years to serve, balance suspended, credit for time served, balance suspended.
54.
So I think it's 45. Is it 45 plus 5? Who keeps farting? Y'all hear that? Let me see what Thugger Daly's saying. It's just hard to hear,
It looks to me like that adds
or
up
difficult to hear.
Let me read that back to you. What the recommendation is? Y'all are
See if I
recommending
can find
20,
Thugger Daly.
serve 5,
Oh,
balance
Judge Whitaker's got us.
suspended on count 1, 10 probation consecutive to count 1 on 42, 20 probation concurrent with count 1 on 49, 10
that's
probation
30.
consecutive to 42.
So that's
Is
40.
that what you said, or to 49 on count 50?
And then there should be another 5 somewhere. They're asking for 45 years to serve 5 commuted to time served and 5 years suspended.
And then on
So time
54,
served would be
5
30
to
years
serve
probation.
consecutive
Shout out to my
to
dog,
40
Thugger Daly.
to 50 and suspended.
If he gets 30 years probation,
What
that'll be
is it? What are
amazing.
you
But that's still
suggesting?
crazy.
Trying to understand what your recommendation is.
I think the 5 was to serve concurrent and then
54 has to be consecutive, right?
I'm sorry, it doesn't have to be consecutive.
So
Fulton County, we
that would
gotta
really
do
be
better with our
45,
chairs.
right?
Yeah, 45 to serve 5. And then that'll be suspended because he's already done time.
You serve. And you said 45 serve 10, but I don't see where that's coming from.
I'm sorry, it's 45 certified because I didn't do the balance suspended on that, the weapons charge.
All right. Anything else you want to present?
Yeah, sure, I know what to have is family members get an opportunity to speak with this. What we envisioned was not to just come in here and blindly ask the court to give him probation without a plan. I don't know what the court's take is on this, but a lot of this seems to be the situation where we have back and forth. Something happens to someone, and then we have something happen to someone else. We're trying to minimize his involvement going forward with other criminal activity going
Well, there's never a need to engage in
Yes,
criminal.
correct.
I want to rephrase that.
forward. I understand. What, or the perception, right? So what I've seen here is, without throwing anybody else under the bus, other individuals still carrying weapons under
Oh, y'all can see.
presumed, that I'm presuming that would be the reason why, is that you feel that you are somewhat at risk, despite that being against
Judge Whitaker does not like that excuse. You're
The
what
law.
we're lawfully allowed to do.
you're telling that to the wrong judge, lady.
I don't even want the feeling of that, and I think the best way to alleviate that risk feeling is to remove Mr. Rowan from these situations and to have a plan going forward
Okay.
about what he's going to do with his life. He and I have spoken extensively about it.
That's good.
Of course, one cannot make
Get him out of Atlanta.
inside the jail to an extent. A lot of his plans involve leaving the state entirely, which I support. That would alleviate a lot of the risk.
Okay.
It's not just a risk for him, but as we've seen in the facts here, it becomes family members, other people, friends that become unintended targets of these various acts. On short notice, we weren't able to lock in a lot of provisions for what he could do and what we hope he's going to do. But I do want his family to at least discuss with you about the plans that they have, so that the court understands that we're not to say, hey, just let him go. We'll hope for the best. No, we have something.
Okay. Have you discussed with the family what those plans are?
I have.
Okay. Well, why don't you let me know what they are?
So generally speaking, his aunt is a business owner. She owns a number of businesses.
Nice.
So she's able to employ him. It's like, one is like a lawn care service. got several contracts for that.
Is this local?
Not local in Atlanta. I think it's Metro Atlanta. Is that correct? Yeah.
Pretty local.
That's still local. Get out
What other
of here.
ideas?
So that would just be the first one.
Yep.
Judge Whitaker does not want him here.
I would like for her to speak about who she reached out to out of state. So she's got other relatives out of state that she was able to speak to. I wasn't able to speak with them directly, so that's why she went to the court to allow her to communicate directly about what those plans are.
Okay.
Would you like me to clear everything on?
Not to just tell me what her idea is for his rehabilitation.
Oh, okay, he's got his aunt up here. Shout out to Auntie.
Good afternoon.
My name is Marquita Cook Johnson. I am Damekion's maternal aunt. I am a native of Atlanta. I'm a military veteran. I do own
Thank you for your service.
in DeKalb County. One is a spa and wellness retreat, and the other is a boxing gym, which my partner and I own together. This was a very short notice. I do understand as far as my goal is to get him out of Atlanta as a whole. Prior to his arrest, I had taken him on his first out-of-town trip to get him acclimated to traveling and just seeing what is outside of Atlanta. I was stationed on the West Coast in California. I have several connections there, and as well as Virginia, mostly states where military people reside. I have reached out to a few of my fellow shipmates who are now retired, like I am, that are in a position of mentorship. I feel like for Damekion's safety and as well as my family's safety, it is best for him to relocate as a whole, and also to have realistic expectations. I have in the past had custody of Damekion. He knows I run a very strict household, but even as an adult, at this point, he needs to have a curfew because outside is not the greatest place right now. So, under the terms of him being able to come for immediate employment. My partner is also law enforcement as well in Rockdale County. So in order for him to come and gain employment with us, he will have very strict accommodations. And like I said, the long term is to get him relocated out of it.
All right. Thank you.
You know, Judge Whitaker isn't a fan of
Mr.
him
Garlington already served on
them
this
sticking
case?
around family.
Your Honor, Mr. Garlington has been in since September 28, 2022, which was 974 days.
All right. Anything else from the defense?
The custodian will be able to correct, but I think it might have been May when he got arrested. I checked Odyssey, and that was the date.
Ms. Shelley, can you let me know what you show for his time served so far?
As far as the jail
Pre-trial?
law, you said what now?
Pre-trial? Yeah. Well, yeah, in jail.
I don't have access to the pre-trial
don't?
system, just regular felony.
Okay.
Things.
Well, darn. What do you show? I mean, there's an arrest date of May 11, 2022. Whether he was released and
There's
rearrested, I don't know.
Damekion.
Oh, okay. Yeah, well, that part I don't think would count in his favor. I don't really know how they. But it wasn't on this case.
What do y'all
If he
think
went
Judge
to prison,
Whitaker is
it would
gonna
have been
do?
for some other case?
Custody on this case, even though he went to prison on the case. I'm not saying his prison time,
I
I'm
don't-
talking about when he was first arrested was May 11, 2022.
Okay, well-
Who's that speaking?
It's either 974 days or 974 days plus about 4 more months, right? All right. All right. Anything else from the defense?
All right, what's it going to be,
All right.
Judge Whitaker?
Any rebuttal, I guess, from this state, which I don't know if that's the thing, but anything else from the state?
No, Your Honor, I believe that you've heard a number of the wiretap evidence, within the first trial, Your Honor, that we don't need to reiterate. It is the state's position that
Mr. Garlington was given an opportunity to redeem himself when he was resentenced in 2020. And as opposed to working with his aunt or as opposed to leaving the state then, that's not what he did. He re-engaged in gang activity in which we have the text messages regarding the stabbing of Mr. Bennett. And while there might not have been payment, Mr. Adams, after the stabbing of Mr. Bennett, surely reached out to Mr. Garlington on multiple occasions to try to get payment for that particular incident, and either never transpired, but there was some expectation of payment for that act to be completed. Again, after the murder of Mr. Drinks, there was laughing about the murder on the wiretap. There was a concern about cleaning the vehicle.
Still hasn't been solved. Great job,
and that
DA.
is all from Mr. Garlington's mouth and words. There was concern that other co-defendants were going to tell, and how do we get that person not to speak? So Mr. Garlington unfortunately never learned his lesson the first time around. If he had, maybe we wouldn't have been here, and that's
Okay, thank you. I'm going to take about a 10-minute recess, and then I'll be back with the sentence.
Oh, wow. Okay, so we're going to get into it. What is Judge Whitaker going to decide? We got to get Judge Whitaker on the channel before she goes to the Supreme Court, which I hope she gets it. There she is. She's back.
Can we get Mr. Garlington back out? Can the state provide what the statute for aggravated assault is on that lesser on 49? Thanks. 49, yeah. You have this. Okay. Yes. And they've null prossed 40, 43, and 50.
Okay, so it looks like he might get it. I heard no pros, so we'll have to see what happens. Looks like he might get a good deal.
All right. We're back on the record. And I have taken into consideration the state's recommendation, the defense recommendation, the evidence that's been presented. I also am obviously aware of the evidence that was presented in the other trial, and I have taken a look back at the sentences that this court imposed for co-defendants from the prior trial, including co-defendants who were charged with some of the counts that Mr. Garlington is currently charged with and has entered an Alfred guilty plea to. Also taken into consideration his prior record as well as the prior records in the other cases in which this court sentenced. Also, other than one of the sentences imposed by this court in the first trial, the sentences that were imposed were joint recommendations, and I've taken that into consideration as well. The sentence for count 1, which is the RICO count, is going to be 20 years to serve 5, the balance of 15 probated. Count 42, the sentence is 20 years, serve 5, balance probated concurrent. The sentence on count 1 reduced, I'm sorry, not 1, count 49 reduced to aggravated assault under OCGA 16-5-21. Is that what you said, 21? Okay. Is 20 years to serve 5 with the balance probated concurrent with the other sentences. And I'll note in that regard that one of the defendants charged with that set of crimes was found not guilty, and 2 others, the state decided to null pros the counts against them.
Yeah, thank you, Judge Whitaker.
In count 50, the sentence is 20 years, serve 5, balance probated concurrent. And then the sentence for count 54 is going to be 5 years consecutive to count 50. And it can be suspended upon successful completion of probation. So that's essentially 20 years, 5 to serve with credit for time served. 15 years probated, followed by 5 to serve, which can be suspended and will be suspended as long as the probation is successfully completed.
Nice.
Special conditions of the probation: no contact with any of the victims in this entire indictment or with any of their family members.
Sounds like you got a good
No
deal.
contact with any gang members from any gang whatsoever. No gang paraphernalia, no gang associations, no guns, no replicas of guns. You need to secure full-time employment within the first 6 months after you're released from probation. You need to sign a social media waiver and a Fourth Amendment waiver. And that is going to mean that during the entirety of your probation,
You need to shut
law
the
enforcement,
fuck
at
up.
any time they want to, can look at your social media posts, can search your person, can search your home, can search
Stay
your
off the
car,
internet.
with or without probable cause, to ensure that you do not have any gang paraphernalia, any guns, any drugs, anything you are not supposed to have. You need to secure your GED, which I know you told me yesterday you were working on it and had gotten to parts of that already. Go ahead and get the rest of it within the first year of your probation. And I am going to require that you stay out of Fulton County for the entirety of your probation.
Good.
All right, that is the sentence of the court. I hope that, as I have said with the other defendants whom I've sentenced, that this has been an opportunity for you to realize that the direction that your life was going is not a
She's
good
so
direction, and that you are determined at this point to turn your life around and make good decisions from here on out. Associate yourself only with people that are going to help you to stay on the straight and narrow. So you've got a little bit of time left to serve before you're released. I think a couple of years at least, but go ahead
years.
and do that. You can be working on your GED and on job skills while you're in prison. Good luck to you. And I hope not to ever see you again, because if you violate your probation, you're coming before me. So let's make that not be a thing. Okay. All right. Good luck to you.
There she is, man.
What?
Judge Whitaker is amazing. Oh my
All right.
goodness.
That concludes
Judge
court for
Whitaker's
the day.
GOAT. That's it. Shout out to Judge Whitaker. Super fair. Doing the right thing. She's so good for the community, man. Getting these guys, helping them get back on the right track. And of course, the DA's office, they didn't have their case together. So there's nothing to show that Damekion Garlington had anything to do with the murder of Shamil Drinks or this RICO in general. But he is going to have to serve 2 more years. He's going to get 20 years probation. And I think this is totally and completely fair. He needs to stay out of Fulton County. He needs to get out of Atlanta. Just start over, man. What do y'all think about this? Shout out to Judge Whitaker. Wish her all the best. I'm sure this isn't going to be the last time we see her. Let me know what y'all think in the comments and in the chat. Wow. Judge Whitaker, the GOAT. She does not play. She does not play. That was amazing. Amy said she is amazing and very fair. Yeah, we gotta connect with Judge Whitaker at some point and have a conversation with her. Amy was picking on the auntie. Hey, leave it auntie alone. All right, let's go ahead. I know y'all want to get back into Karen Reed, so thank you again to everyone who was in the building. That was absolutely amazing to see. So Damekion, you know what you got to do, man. Do the right thing. Get your life together. You'll be all right. All right, let's get back to, oh God. We got Judson back on the stand. The good doctor is back on the stand. Let's see what he has to say. Hold on a second. Gotta exit out of this. Get out of this. All right, here we go. Let's fast forward a little bit. Hopefully it doesn't jump ahead on us again. Actually, you know what? Just to avoid that happening, let's do this. Here we go. Yeah. Yep. We're still waiting on Monktonk. I know my guy Happily Angry Lawyer is working on it. They're working on getting them out of there. Judge Whitaker is the GOAT. post this for y'all.
Go ahead, Mr. Lassie, whenever you're ready.
All right, Alessi, do your thing. Here we go.
Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same.
He said,
We
yeah.
had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So your
on any
bones are
bone.
on the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis
Don't
on
interrupt him.
any
He's going to get
bone in the
testy.
body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer,
You did say that.
you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand, okay? So that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm is either from the shoulder down to the tip of the fingers is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's
your calculator
of
out,
force
buddy.
from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a
He doesn't
force
even know what he's talking
calculation
about.
of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like
What are
to
we
start
doing?
with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out
Rude.
towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. Well, so let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay,
Tell me when you're ready, sir.
go ahead.
So let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for
Okay.
the impact window.
Be interesting to see where he's going with this. Oh, this is intense.
Okay. Question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you
Breaking it down.
took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical, semi-algebraic application of the numbers, correct? You
Correct.
divide,
We're doing a little simplification in terms of the crash
Yes.
pulse shape, but generally, yes.
right. So, but let's take the conservative number, the lower number, 2188 that you came up with. Do you know from the literature As you did with the head, you went to the literature and said this is how much pounds of force the F you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to
No.
do your calculation?
No.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals,
Yes.
the metacarpals, and the carpals?
Correct.
How
It's
much
not that
pounds
complicated of a
force
question.
do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but
Answer
I'm
the
asking,
question,
you know
dude.
from the literature, not a calculation. Doesn't the literature tell you? Can't you go to the literature like you did with the head, and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that.
Thank you.
So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
He doesn't know.
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting a taillight, you're going to need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of,
The
contact
Lexus
area.
SUV. Let's assume, I'm sorry.
Can you repeat the question, please?
Absolutely. Thank you. Let's assume
Yeah, he's trying to figure out where
talking
Leslie's
about
going.
This Lexus SUV, right? Well, let me back up. You don't know where exactly, under your theory, that there was a contact. You don't know, you testify to on direct, you don't know exactly where that point of contact is, do you?
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the tail light, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, correct?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was, correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
Was it his DNA?
Sir?
It wasn't his
Your Honor, I
DNA.
move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making assumptions.
It wasn't his DNA.
What you view to be certain data, and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the tail light at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers,
Okay.
okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So
300.
you got above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't. What was the? You said
2,180.
You said dyslexic. Or do you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear
You
it.
came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay,
Absolutely
so
not.
let's go with your number of force from this
The
vehicle
voice
of
inflections are killing me.
2,188.
No, what?
I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
300
Sure.
pounds.
So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight,
He's
it
starting to
takes
get
much more
frustrated.
force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this?
Hey, yo.
I don't sink in as far.
Hey,
Has my
doctor,
weight
this
changed?
is a family show. We can't be talking about spreading loads. All right, Jesus.
On the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed?
18
And
years,
weight is
18
basically
years.
force.
That's what happens
no,
when you spread
but
your
I've
load.
distributed it over a larger area, so for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a
6,000 pounds. Is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Yes.
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words,
Spreading loads
you
on the
can
bed is
get a
wild.
break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper,
Oh my goodness. This is
potentially, yeah. But from a taillight or a broad flat surface, no.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force?
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel.
He's
If
saying
you hit a very
including the
narrow
taillight.
part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger, so your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, excuse me, sorry.
take the car piece by
Mr. Wolf,
piece.
can you pull up a slide from Mr. Wolf's, or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number, though, Mr. Leslie? So we can keep track?
Mr. Wolf does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just up there.
So now Leslie's just going to
The
break
back
it down
hatch,
piece
yes.
by piece. The tail light, could that have done it with 300 pounds of force? No. The back hatch, could that have done it, doctor? No. The
You have one
spoiler,
just
could
for
that have done
your
it? Yes.
gate.
The bumper, could that have done it with 300 pounds of force? No. Okay, so you said the spoiler. It could have possibly done
one
it
measuring the
300
height.
pounds of force.
There we go.
Right, doctor? Yes.
Thank you.
Thank
Okay,
you.
this is your slide presentation.
Here we go.
Is there any part of the back of the Lexus SUV that
Jesus.
has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand.
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right, so now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did.
So-
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that?
I'm sorry, what, to the hand? Just the hand or the whole arm?
I'll
being
take any
intentionally
part
dense.
of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes. Yes.
Right here.
Yep.
So that transition between the two body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well. It's a much more narrow loading condition.
How about the corner of the tail lamp?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just want to
I'm
keep
sorry,
track.
Your Honor. Yes, Mr. Wolk. Yes,
All right, thank you.
thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe?
Yes.
Other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy.
Yeah. Oh my God. I should be an attorney. I told you guys, I said this, the medical examiner is going to come up. This guy's not a medical examiner. We talked about this. The medical examiner said these injuries were not caused by a car accident. Who were you, Dr. Welcher? You remember Dr. Scorty Bello? I told you guys this was going to happen. We went and looked at it during the break.
You read the autopsy report, correct?
Correct.
Are you implying, and it's a question, that Dr. Scorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there would be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
This guy thinks he's
Correct.
smarter than a medical examiner.
And
Get
you
the fuck out
Are
of here.
saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I didn't use proof in my question.
Ask me about the opinion of a medical examiner. I'm not a
Hold
medical.
on. Only one person at a time. Mr. Leslie, let him finish.
Objection, argumentative.
Question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for Madam
I
Court
understand, and I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no.
It's getting
Except for the
feisty.
skull.
Except for the skull.
Correct.
Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scorty Bello, in the conclusion she reached in the autopsy report that you read?
System.
Did you read the conclusions of Dr. Scorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
Guys, I have so much I want to say on this, but we're going to skip ahead and get through the testimony. You don't get to make these type of determinations and then say, oh, whoa, chill. I'm not a medical examiner. Relax. No. You don't get to do that, sir. You open the door. You're saying what would have happened, how much force would have needed to be applied, why those scratches are there on the body. Tell us, sir. Dr. Welcher, please. Your expert opinion, let us know. Those are 5 Saibas today, by the way. Team 0 to 6, y'all might have a win. Y'all might finally get a win. We'll see. Here we go.
Thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, I would like to talk now about your paint exercise. You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise, and what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay, you want to call it a blue paint test?
Sure.
Okay, let's call it a blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okey-doke.
So your blue paint test involved painting the right rear tail light blue, correct?
Correct.
Positioning the test subject behind the tail light, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know. Well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them were at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one,
Okay.
okay? Now, did
Come on,
you
man.
conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus tail light on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So let's.
Dang,
did you
Your
do
Honor.
a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mm-hmm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you
Of course.
do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
We said that earlier
You could
too.
have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You
If
could have
you-
done that.
If you use the right crash test dummy,
Right.
and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
So, your assumption, as I understand it,
Jeez.
that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir.
No, There is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
Do you know, do you have a hypothesis at what speed you believe there was impact? Do you have the point of impact speed?
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough
know
information
anything.
to determine that.
Let's talk about the other information you don't have.
Okay?
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
Correct. You don't know that. I want to go through the information that you don't have.
Okay, doke.
So you don't have that. You don't have the point of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
There you go. Miss Little and Karen over there exchanging eye
paint
rolls.
Tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken tail light was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the...
He's being super
as soon as
difficult.
Mr. Wool gives it the slide 23, I believe it
For
is.
no reason.
I'm sorry, what slide?
Well, I want Mr. Wool to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87?
Do you want them,
I
people that
jumped
were there
ahead
for
again.
that
I hate
entire
when it
window
does
of
that.
time? Or
Yeah,
just...
Yes, 12
Hold on a
to 1.
second, guys.
Oh.
So Mr. Alessi, just move to the last question.
Right,
Talk
sure.
about here.
So, sir, did you
Sorry, guys, give me a
assume
second.
that there were cars parked out
Here we go.
with the blue paint exercise? Is that
Which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
let me ask you this. Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you
Of course.
do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
You could have done other tests
Oh my gosh.
where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You
If
could have
you-
done that.
If you use the right crash test dummy,
Right.
and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts
That's
are
true.
so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
So, your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir?
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
Do you know, do you have a hypothesis at what speed you believe there was impact? Do you have the point of impact speed?
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Exactly. Let's talk about the other information you don't have.
Okay?
You don't have the information as to the, from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
Correct. You don't know that. I want to go through the.
He doesn't know anything.
You don't have.
Okay, dope.
So you don't have that. You don't have the. point
He's
of
super
impact.
passive aggressive
You
too.
don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where.
Defensive for no reason.
Under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir. I understand
Paint transfer
you use
testing.
paint
It's
tests
crazy.
as the focal point. But aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Woke gives it, the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Wool to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something number and a 50 number, and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
Where's his attitude? Why does he have such an attitude? Dang.
Are you on 33, sir?
No, I'm on 36.
That's crazy.
Mr. Wolk, do you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Wolk, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep. To the farther to the right.
Oh, I'm not the only one that has problems.
Okay.
You
Sir,
still
do
don't
you
have
remember testifying about this? To the farther to the right?
it. Farther to the right.
Yep.
Keep going. Keep going. A
Is
little
that
more.
53 number down there? That column?
Right.
So
can
you
we
take-
can we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns. Like Z is relative to where it started, and then positive is forward, and then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right. We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay. Is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then it's see where the one next to it says minus 53?
Yes.
0.429. If you go up, so it's not a little bit down a little bit, and add, see where it's changing directions at 34.157?
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50-something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now, can you
Just hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward, then it went in reverse.
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80, it went 34 feet forward, then it came back 80, or another 53 feet past where it went.
Exactly. So, you've testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, if I was clear, it initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162.2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Could you zoom in? There you go. No, go back to the left. So that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet
Good
forward?
question.
How do you know that?
So the only data we have is this 10-second window. And so we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake, where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain
Yeah, he's getting
that
frustrated.
the distance traveled forward during this trigger event was 34 feet? Are you certain?
I'm pretty certain during this trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible.
He's getting
I would
super
say I'm
frustrated.
certain,
Okay.
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow-orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral?
I think it's either neutral or park, but I'm pretty sure it's neutral.
A 1
Doesn't even know
represents
that.
drive?
Come on, doctor.
Correct.
A 2 represents reverse?
Correct.
Or a 2 can represent slowing down, is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down?
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay, so if Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolk.
And we're going to be here for a minute with Dr. Welcher.
And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Lessie, so is this 30 or 31?
I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you. You see all the numbers in blue font on that slide, sir?
I do.
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do.
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into
Thank
the
you,
spreadsheet.
CPE.
Correct?
Correct. The one exception is column N, where it says ship position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct?
Correct.
As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Now, we're going to keep that up, Mr. Woke, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage, is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So
I've highlighted the slippage.
exactly. So you agree
Shout out to Slippage.
that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%.
So let's
In reverse.
Okay. Got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
It doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depress greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. You understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So, applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at sidebar on this, Mr. Mayor.
Oh my gosh. Judge Bev calls the most sidebars when the defense is up. That's 2 today, just on her alone. Let me read a couple of these super chats and we'll keep moving. Shout out to CPE in the building with the 20 bomb. Oh my goodness. Says, because I feel so bad for the Commonwealth and I will never pay you a handsome tax. But you think it though. Shout out to CPE. Also, shout out to my guy Travix in here with the 10 bomb. Says the defense is making a mistake here. Spending too much time on this is putting everyone's mind at that he was hit by a car. But the details are wrong. Rather than he wasn't hit. Well, Travix, maybe that's the defense's point, is that he was hit by a car, but not Karen's car. Could he have been hit by another car? Who knows? I don't know. Anyway, I don't see it that way. I see it for what it is. There's a lot of speculation here, a lot of reasonable doubt when it comes to this doctor's testimony. I don't know why Paul's there. He's falling asleep. Other than to mean mug the jury. Get that dude out of here, man. Is he going to testify?
Yeah, Your Honor.
Yes.
Thank
Why
you.
is he there?
Dr. Welcher,
Never know, Travix.
am I correct in my understanding?
Remember Jennifer McKay?
That
There's
you
a lot of people
believe
driving there that night.
Under your theory, the Lexus for event 1162-2 backed up 53 feet. Am I correct?
No, it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87, okay?
Correct.
And your further theory is that it did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Do you want them, people that were there for that entire window of time, or just?
Yes, 12 to 1.
Oh.
So Mr. Alessi, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, yeah, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in time, there was a vehicle behind it.
I'm sorry?
There was a vehicle behind it.
Just one?
That is my understanding. In terms of on the street, is
On
your
the street,
question?
exactly. And what, do you remember the type of vehicle?
Yes.
What kind of vehicle was it?
An F-150 pickup?
Did you have any understanding as to whether there was a Jeep vehicle on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep-type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
Who owns the Jeep? We just talked about this, y'all.
Let that answer stand what he's just testified to. Just go
Who
ahead.
owns the
so-
Jeep?
Dr. Welcher,
Jennifer McCabe.
what I want to do is to have you, using your data, you say 87 feet for the backup, correct?
Correct.
1162.2.
I told you guys.
24 miles per hour.
Uh-oh.
Is there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with the vehicle out front?
No, the vehicle had left prior to the end or prior to event 1162-2.
How does he know
What
that?
information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Miss Reed's interview statements. I have
Jesus,
statements
that's
of
your-
a number of witnesses. I don't know if I'm allowed to say the names.
Let's not.
I was just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements at multiple statements from the same witnesses at different times, indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle, parked out front of 34 Fairview. Is there a likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60-something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I would need my slides.
It was 50.
50,
okay. Yeah, go
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually why I have that diagram showing it off to the side.
That's
I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started, and therefore all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet,
He
correct?
doesn't even know where the car
87 feet
was.
backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an hour.
So if anybody who's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No. And
Here we go.
No.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow, I've done it. But
At
again, that's been
25 miles an
decades.
hour?
Right. So 87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road And for 34 Fairview, it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
Correct.
No, there's some spots, if you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right?
Conditions
the weather,
have nothing to do with where
I need
you
to
start.
finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question, please.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur, a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum, and low lighting, you don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not possible.
So your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah. Highly, highly unlikely. But
All right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality.
Y'all think this helps this man? Oh, what a way to answer that question. Oh, wow. 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 And y'all were laughing at me when I brought up a reindeer running past and hitting the taillight. This guy said the Lexus could have been shot into space. Wow.
On the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible.
I have no words.
It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah. Highly, highly unlikely. But
All right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms of the Lexus itself, because you,
Yikes.
under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No, it could have.
Okay. Now let's go to the next topic. If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167. Now, as I understand your testimony, Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more
I'm glad
specifically,
we're finally getting to the arm.
it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know. I'd characterize it that way. What happens is, there's 6,000-pound vehicles coming, and he's standing on a, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sir, I'd like to
I'd like to answer your question with a slide that I have that addresses this exact point.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
Do you agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones.
I know it's not your fault, but
On the
sometimes it
image,
doesn't
the
show.
upper left. I mean,
Yes.
technically, the ones right to the right of that are also on the biceps and triceps.
Right, but
the
I'm talking
biceps goes all the way to the elbow, so do the triceps.
Right, so I'm talking about the two that are the farthest up.
Correct.
All right, would you agree that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
Yes
more
or
or
no?
less. They're angled down slightly, but more or less horizontal.
Okay. Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
Correct.
Gotcha.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle, if this is me and this is the car, it's pushing and pushing across like this. And with your arm bent like this, it's going to cause laceration as it pushes my arm away. It pushes like that.
Okay, I
And
got it.
My slide shows this quite clearly.
So you disagree, you do not agree that the injuries to Mr. O'Keefe's forearm under your theory would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with that.
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What I'm trying to do, sir, is to get under your theory, right, given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay. Isn't it the case with your theory that the tail light would have to break, and after the break, the arm would have to maintain contact with the arm as the car moves?
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation you had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, and that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body, it's going to cause it to move, the body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the tail light would break, and also the arm would need to maintain contact with the taillight area as the car moves. Is that your supposition?
So at a point in time, it'll stop contact, but the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right. You don't have enough information to make that determination, do you, sir?
Correct. But we know because of the laws of physics that it has to be
With
some
the
amount
context.
of time. It doesn't
Objection,
occur instantaneously.
non-responsive.
So now we do apply the laws of physics to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. But you didn't do that in your report.
Nope. Always apply the laws of physics. The paint experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this. So that was an engineering experiment to correlate height, position of the taillight relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, you, to answer my previous question, applied.
We heard what he said.
And so what we have ultimately is that there is no evidence, none.
Laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So a simple measurement of height is a physical measurement.
Sir, I have your entire report in my hand, right here. Where in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that,
What?
I didn't apply Newton's second law, as we already went through. But again, those simple positions, arm angles, the possible physical
That's
arm
a big
angles,
deal,
those
doctor.
are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report
Somebody needs to get him a
do
Snickers. He's
you
about to
even
pop.
mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me to where?
Would write a report to say these are the laws of physics. I would say these are the numbers, but for example, the timing in GPS, how a clock times, the concept of a second. What does that mean? Those
He's
are all
getting
concepts
angry.
of physics.
Why is
So
he so
the timing,
mad?
the GPS, the
Dang.
mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
That's not what you asked. You asked me about my whole report.
Sir, if you could, please, I just need to finish my question. Where in your report do you use any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
Yes.
Where?
2A. 2A Roman numeral 1. 2A Roman numeral 2. 2A Roman numeral 3. 2A Roman numeral number 4. 2A Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm?
Oh.
I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
So let's go to 3. You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right tail light of the Reed 2021 Lexus LX 570. Where?
Can you read the next sentence?
I'm sorry. Is it C PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report. Did you apply any force analysis to support 3?
So in terms of the force analysis, I did not do an F equal MA analysis, but in terms of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is, what you cited, number 3, you did not use a force analysis, correct?
So force was applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
So now let's go to the horizontal movement we were talking about with regard to the car. And you can agree or disagree.
Sorry, the picture's on.
I'm sorry, we'll take that down. Do you agree or disagree that given a horizontal movement of the car, vertical lacerations would be an inconsistent injury pattern?
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is, not with clipping, you keep inserting clipping into my question. My question is this. If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you got to give me more. So, like, is it a clipping
what she
contact
said.
or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay, are there only 2 variables you need to answer the question?
But
That's
this
what
is a good
she
start.
said.
All right, so let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations. But again, it depends on what's being hit.
Okay.
So, for example, if I have something that bends as a result of the impact, it could bend up and create a vertical laceration.
So you would agree, based upon what you said, that generally horizontal movement of a car would be expected to cause horizontal lacerations. Is that-
Generally,
Okay.
yes.
Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the tests.
Do you want? We bring up a slide. Will that
I'd
help
love to
you?
bring up a slide.
We're going to be running the thing, so we'll just bring one up, and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask you for it. But I think we've got a slide for you. And what number? 111 is on the screen, sir.
Big man.
Is the blue paint more predominantly on your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Probably. This is the one where I actually walked sideways into the back of the car.
I don't
The one where the car's moving is probably a little better representation.
Sir, I'm just asking you a question about this slide. If
Okay,
you could just focus on this slide here, and if you can't answer it, so be it.
I just answered it.
Is the blue paint featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
All right. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with the taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
But don't you have to select among other choices this outstretching of the arm? You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion it hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right.
did.
I
That's
am
fair.
not going to be asking any questions that involve the taillight in any fashion. So what I'd like to do is to go back to the question that I'm asking, which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation
He did
of
ask that.
Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay. So, are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative orientations?
No, I think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything in writing?
No, I don't believe so.
Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight on the Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method earlier has the scientists identify various hypotheses, go with the data that supports it, but you show your math as to why you're rejecting hypotheses. As you said you rejected them, I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with the Lexus. I did backing tests. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not, so I eliminated that as a hypothesis. I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
I understand you say you did a bunch of tests on the vehicle. My question is, did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do 1 static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where's the documentation for that, sir?
It's in the file. I gave it to you. Some of the slides are some of it.
All right, so Mr. Alessi, I think if we're going to,
I'm going to move on, Your Honor.
So
okay, but Mr. Alessi, hold on, we're going to do that voir dire.
Can I ask, I just have one other area, Your Honor. I can do it in short order if I could, please.
I wasn't finished my.
Go ahead, finish your answer.
So slides 109, 110,
She said, "Go ahead, I'm trying to go."
111, actually through, I guess 121 deal with the testing of the hypothesis.
We'll come back to this at another time, Dr. Welcher. So what I want to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this will be my last question, did you engage in any confirmation bias
Wow, that's
in
rude.
terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right,
debate.
so, okay, thank you. All right, so jurors, we're going to send you home because we still have work to do here, and we don't need you waiting there while we do it exactly. So, tomorrow is a half day. We'll see when exactly that half day ends, but we won't be here until, we won't.
Oh, we have a half day tomorrow. Nice.
Those 3 cautions: do not discuss this case with anyone, don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. The 4th admonition, please be very careful with your social media use. See you tomorrow morning.
There it is. She looked at him like, "What you laughing for? Boy, you got up here and got cooked. Get your, I saved your butt." That's how she's looking at him. Like, I don't know what you're laughing at, dude.
Please be very
But get up out of here. What do y'all think, man? I think she did save Dr. Welcher at the end. He was getting awfully testy in there. A little bit frustrated as well. Oh, man. All right, let me read a couple of these super chats and then I'm going to get y'all up out of here. Let me see. Did I miss any? I did. Shout out to CPE in the building with the 10 bomb. Says, okay, this is just so we need to take a deep breath. Take a walk because use the frustration. This is witness is real. Dudes have credentials, I think, but doesn't know or sold himself to the game. Just saying. Yeah, it's clear he has a motive and objective, and he's trying to uphold his integrity as a witness. He's trying to make sure he remains and looks credible. And it's unfortunate because, I mean, he's really looking super foolish out here. I hate to see it. Yeah, J-Dub said bro was salty AF. He was super salty. So hopefully he can get it together because it looks like he's going to be here for a little while. We're just getting to the arm. All the bruises and cuts on the arm, what could have most likely happened. We talked a lot about the pressure it would take to break hand bones. It's going to be interesting to see how this cross continues to go tomorrow. We've got a half day tomorrow, so y'all won't have to be here all day, but we had a good time, man. Shout out to everyone who's in here. Amy's already sharing the video for tonight, 8 p.m. Eastern Standard Time. In about 3.5 hours, we're going to be live again. I know. If you enjoy listening to some music from the independent artists here in the community, make sure you tune in tonight, Song of the Night Live. It's going to be a good time. We're going to hear some great music, have fun, and y'all make sure you stop by. And as always, we're going to be here tomorrow. If you haven't yet, subscribe, hit the notification bell so you don't miss any time that we go live. Big shout out and thank you to everybody who supported the channel. We had a bunch of y'all. We had In Blue over on the PayPal. We had Slim Life New Jersey, I want to mention as well. We had Rhonda over on the Cash App. We had Donna was over there too. Shout out to Donna and Rhonda over on the Cash App. And then big shout out and thank you to everyone who sent in super chats today. We have 8 Baboon, Slim Life again, Kara Hampton, CPE doing it big, Libby22 SC Girl, Melissa B, Mr. Brown, appreciate you, Cynthia Hartz, Tay Toon with the anniversary, 3-month membership anniversary. And then we had my guy Travix, and as always, my awesome, amazing Amy up in here. Support. All right. I hope y'all have a great rest of your afternoon. Make sure y'all tap into the show tonight. And as always, you know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace.